Today we're going to talk about Marcellus Williams, a man who has been fighting for his innocence for almost 2.5 decades. The state of Missouri could schedule an execution date for Marcellus Williams as early as January 3rd, 2024, so at the time of my writing this, that's 5 days away. You can sign a petition to help. You can do that right now by going to the description. It'll be right in the top of the description. You can jump over to this page. All you have to fill out is your name, your zip code, and your email. The phone field is here, but you do not have to enter your phone number to sign the petition. And don't think that this is invaluable because it's worked before for Marcellus Williams. Now we're going to get into the timeline of this, how I typically do these videos where there's a lot to cover. Again, this goes back to 1998, not just for the investigation, the trial, the direct appeal, any motions for post-conviction relief, and everything that's come forward since the Innocence Project and their related attorneys got on board with their DNA experts to help fight for this man's innocence. So what we're going to do is we're going to take a quick look at August 22nd, 2017, which is casually known now as the day Marcellus Williams didn't die. And from there, we'll get a look at what happened around that day where he was scheduled to be executed by lethal injection at 6 p.m., and his execution was stayed just hours before he was strapped into the chair, something that he could be facing again in the next few days. So again, X out of this video, sign that petition. If you're watching this and there's already a result, we hope it's for the best. After taking a look at August 22nd, 2017, which is obviously a huge day for Marcellus Williams and the team that's been fighting for his innocence, but it's also a great day to show that social media and petitions do work. We're going to see why that's the case. And then we're going to go over a top-level summary of the information in the case, what incident he was charged for, all those little details, plus a summary of how we're at this point today in 2023, about to enter 2024. So we'll get to look at some of the reasoning for why appeals and motions for post-conviction relief were denied by different courts. And we'll also get to look at the arguments that the Innocence Project is making on behalf of Marcellus Williams to fight for someone to give him a chance to present new DNA evidence in court. Because today, currently, at the time of this recording, no trier of fact has looked at this new DNA evidence. It's a lot, guys. This is 2.5 decades that this man has been going through this, and there's so much to unpack here. We're going to talk about the Postman's Gambit for striking Black jurors. We're going to talk about, Supreme Court decisions on the degree of reasonability when it comes to capital punishment, death sentences, and the clarity or lack of clarity on Supreme Court and different state-level rulings on that. We're also going to talk about the issue of post-conviction relief for people like Marcellus that maintain their innocence. Missouri, not really a great state for post-conviction relief processes, and we're going to see that unfold and get a little bit of insight on states that are doing it better or trying to do it better. So if you stick around just for the summary of Marcellus Williams' story, I hope it sparks a fire for you to understand how important the exoneration of one person can be, how important the fight for post-conviction relief for one person can be. If you stay around longer, you're going to learn so much about just broader problems with the system and how we have not caught up to adapt to new technological methods that can exclude people as being the person that committed the crime they've been accused of and spent decades already in prison for. In this specific case, we're going to get to unpack a lot about not just the use or lack of use of DNA evidence and a willingness to disregard a lack of physical evidence to exclude somebody as a suspect, let alone let it go to a conviction. But we're also going to talk about unreliable witnesses and testimony, monetary rewards for testimony, discovery issues. There's a kitchen sink here, and we're going to look at that. And remember, you can hop right on over here in the description, sign this petition. You don't need to enter your phone number to submit the form. And there was a petition that reached 200,000 signatures in 2017, right before, hours before he was set to be executed, so don't think that it doesn't matter. The link's right there. You can do that now. I'll keep mentioning it. So here on my screen is Marcellus Williams. He's been in prison so long. I mean, this murder happened in 1998. He was convicted in 2001. This is not the era where we can go and find many pictures of him. So we've got a picture that his legal team took on a visit with him in the facility that he's being held in custody. And then we have this one family photo. There may be others scattered about, but if you do a quick search, you're really not going to find all that much. Like, you can see the gap in time from when this man was a free man to how old he is now. He's in his 50s now. He's 53 years old, and he's obviously not 53 years old in this picture where he's still able to have his freedom to be with his family. Now let's first walk back to August 22nd, 2017. And I like that Leonard Pitts calls this the day Marcellus Williams didn't die, because he really was about to be strapped to that chair for lethal injection at 6 p.m. on August 22nd, and just hours before, Missouri Governor Eric Greitens was like, hold on, I'm going to stay this execution, we're going to put it on pause, and I'm going to form a board. And he used a really old rule to do it. It was only used like once in Missouri's history, to put together 5 retired judges. They're going to make a panel, and they're going to look at some of this new DNA evidence and decide if something should be done in terms of maybe commuting this guy's sentence. They were supposed to form a report and report to Eric Greitens, and we'll get to what happens with that. But let's go through this day. So just hours before he was to be strapped down and pumped full of poison, Williams, convicted killer of Felicia Gale, and that's Felicia Gale here on my screen. The way she was murdered was really brutal. Like, there's no doubt about that. And it was a high-profile murder because she was a reporter for the St. Louis Dispatch. Her husband was well known. Her husband ended up issuing a reward after police couldn't find any suspects in her murder case. We're going to hear more about that, but just so you have a face to the name, this is Felicia Gale. So Felicia Gale, a former reporter for the St. Louis Post-Dispatch, received a reprieve. Missouri Governor Eric Greitens stayed the execution and announced formation of a panel to review the case. To be sure, no one will ever mistake Williams for a choir boy. At the time he was charged with Gale's 1998 murder, he was a 29-year-old with a rap sheet including convictions for burglary. He was also a suspect in an armed robbery at a fast food restaurant, a crime for which he was later convicted. Whatever his other sins, though, there's reason to believe Williams may not, in fact, have been the person who stabbed Gale 43 times during a burglary. Yes, 2 witnesses, a jailhouse snitch and a woman Williams had dated, and who was addicted to crack cocaine, and had other outstanding warrants that she was promised help with from the prosecution. We'll get to that. Both came forward after a $10,000 reward was posted by Gale's husband and claimed he had confessed to them. So these 2 witnesses come forward and say that Williams told them he killed this woman. And granted, a piece of the victim's property was found in Williams' car, and the girlfriend led police to a laptop computer belonging to Gale's husband. She said William had bartered it for drugs. Now, if you don't stick around for the full video, you're going to miss some important details that, in my opinion, would undermine the confidence in the verdict of the trial here. Williams had argued that DNA that was found, even back then, so they didn't have DNA from every piece, they didn't have every test available to analyze everything that they found, but they did have some DNA, and they couldn't find Williams' DNA on it. But they also never tested any DNA at the crime scene, or anything related that they had, for the girlfriend, the ex-girlfriend that he dated for 2 weeks or whatever. They never tested to see if it was a match for her. And we're going to find that the laptop salesman, the person that bought the laptop, he had stated during deposition that Williams had told him that it was a laptop that came from his girlfriend that he wanted to sell. So that wasn't able to come in front of the jury during trial. And, there's 2 questions there, right? Like, if you're the one that stole a laptop, you might go and just say, oh, it's someone else's. You're not going to say, hey, I sold this laptop. Can you buy it from me? Because they're not going to be able to give you money for it. Or maybe there's some truth to it. And there were 2 other witnesses that had seen the girlfriend walking around with this laptop that summer. And it was only in her possession for a limited amount of time. So at the very least, there's 2 witnesses saying that this laptop wasn't just something that was thrown in Williams' trunk after he burglarized and murdered this woman and then immediately went and sold to barter for drugs. There's a lot here. Let's keep going. On the other hand, no forensic evidence places Williams at the murder scene. Kent Gibson, an attorney for Williams, has told reporters that hair fibers and bloody footprints found in Gale's home did not match his client, and bloody fingerprints found there were lost by police and never tested. There's also no witnesses that place Williams at this property, and the murder happened in the daytime. As if all that were not enough, there's this. In 2015, the Missouri Supreme Court stayed an earlier execution date after Williams' attorney pleaded for time to conduct DNA testing. The results of that testing showed that genetic material found on the murder weapon did not come from Williams. Now, the reason this matters is because previously they did some DNA testing and they were just like, oh, we don't have evidence to confirm that this DNA was found on these things that we're examining. But this DNA testing that came in 2015 by a renowned expert, it was verified by other experts. It's currently not ever come before a court or a trier of fact to be examined and make a determination on. This DNA evidence definitively excludes Marcellus Williams as a contributor to DNA found at the murder scene. So we'll get to all of that in detail, but that's the major piece of this puzzle, that in 2015 they said, hey, we looked at this DNA evidence. There's no way he's fully excluded from this, and you're still trying to execute him. So the fact that Marcellus Williams didn't die last week, again, this is referring to August 22nd, 2017, can be chalked up to not justice, but to that most transient and fickle of factors, political courage. And make no mistake, Governor Greitens' decision to block the execution took some moral fortitude, especially given that he's a Republican and a tough on crime. That's the party mantra. But it should never have come to this. A man's life should never have hung in this balance. And one of the reasons I really wanted to use this article to revisit August 2017 is because of this kind of philosophical bit here. It is human nature that human beings are loath to admit their mistakes. It is also human nature that human beings will make mistakes regardless. One of the most grievous flaws of capital punishment is that it requires us to pretend those two things are not true. That is why the court's refusal to stop Williams' execution is less suggestive of reasoned jurisprudence than of a refusal to look too closely for fear of what one might see. And he goes on to say that it's a common affliction where capital punishment is concerned. As a nation, we avert our eyes and thoughts from a system that is racially, religiously, geographically, gender, and class biased. A system that pretends witnesses never lie, prosecutors never cheat, and public defenders are never overwhelmed. All of these come into play in this case alone, but he's right. This is a bigger problem. A system predicated on a capacity for perfection human beings have never exhibited and never will. We avert our eyes from all this and call capricious death justice. But it is really just capricious death, and it will never be anything more. That is the sobering truth of the day Marcellus Williams was scheduled to die and didn't. It's also the truth of that coming day when someone else is scheduled to die and does. And we're going to see when the Innocence Project, their attorneys, step in. We're going to look at the writ they filed to the U.S. Supreme Court, so SCOTUS, right before Eric Greitens issued this stay of execution on August 22nd, 2017. On August 18th, 2017, an argument was made to the Supreme Court of the United States to stay the execution and to consider everything that's going on. And they make some really compelling arguments that what I have highlighted on my screen, it's not just about Marcellus Williams, but also a lack of clarity and a lack of evolution to keep up with evolving technology that will greatly impact the next time inevitably someone else's life is on the line when DNA evidence or other evidence exonerates them. So at this point on August 22nd, 2017, Marcellus Williams gets to live to see another day. And we know that he's gotten to see 6 more years, right? Yeah, 6 more years because we're in 2023. But on August 2022, there were still questions because what Eric Greitens came out to do to order the stay and form this board was the first time in years. This has only been used one other time. So it's kind of like, how is this going to go? And the report that this board is supposed to make is they're only going to report their findings to Eric Greitens so he can decide how to move forward with it. And fast forward a couple years, Eric Greitens has to resign because of some other issue. And it's all left up in limbo. The new governor is going to come in and dissolve this board. No report was ever made. And that's why today in 2023, as we're about to enter 2024, there's nothing preventing the execution of this man. And because the governor had ordered to stay, the Supreme Court never decided to look at the case, look at the filings that the Innocence Project and the rest of Marcellus's team had submitted on August 18th, 2017. And knowing all of that in hindsight, that for the last 6 years, there's been this up in the air I think it's really powerful to look at some of the statements that came out on August 22nd, right after it was announced that his execution would be stayed. And you may remember if you used Twitter back in 2017 and were on this day because Marcellus Williams' name was trending on Twitter. Social media was kind of ablaze. I remember this day. And right after this day was announced, you have people celebrating that, hey, social media literally saved the life of Marcellus Williams. They were planning on executing an innocent man. More than 200,000 people had signed a petition asking for the governor's intervention. At the same time, an energetic social media campaign helped bring the case to the attention of the wider public, and for some, this played a key part in Greitens' decision. The attention this got was really important, Ken Gibson, Williams' lawyer, told Al Jazeera. The decision showed that when people speak, politicians want to listen. Stacey Pratt, executive director of human rights organization Missourians for Alternatives to the Death Penalty, agreed. The voices of the people definitely mattered. Over 200,000 people have signed the petition, calls have been ringing, and his, meaning Greitens' voicemail box was often full. Eric Greitens said, "To carry out the death penalty, the people of Missouri must have confidence in the judgment of guilt." Now, on August 25th, 2017, Kent Gibson, who is a criminal defense attorney representing Marcellus Williams, you've already seen him pop up in articles that we've read so far, and then Maya Foa, who's the director of the international legal charity Reprieve, both interviewed with Democracy Now!, and they discussed an execution of a man in Florida that happened right around the same week that used an untested drug cocktail. So this man, as he was being executed, the drug cocktail didn't kill him. They had to do it again. And then they also discussed how new DNA evidence cited as a, reason that Marcellus Williams is innocent and should not be executed. They discussed the stay of execution and the implications of capital punishment when new technology has come about that could prove someone's innocence, even though they've been previously convicted. Now, I'm going to link to this episode. I'm going to link to this interview in the description. You can go and watch that in full. So Kent goes on to say that, he's been representing Marcellus for about 12 years now, and they'd been trying to get new DNA testing that whole time. And then finally, in 2015, they succeeded in doing that. And one part of that is through the new technique called touch DNA, a DNA profile was developed on the knife handle that was still in Gail's neck when she was found by her husband in the house, dead. And it matched an unknown male, but it excluded Marcellus Williams' DNA as a match for that male. So there was DNA presence on the knife that did not belong to Gail or her husband, and it did not belong to Marcellus Williams. So there's the presence of the DNA of somebody else. And there's no DNA present for Marcellus Williams on the murder weapon. And that's important because pin that, we're going to get to a quote from the prosecutor right after this stay was announced. So Amy Goodman goes on to ask Kent, well, he's been in prison for 17 years. How did this happen on the day he was about to be executed? And Kent describes, and we're going to look at some of the timeline on this. Well, we had the results, and we tried to get a stay from the Missouri Supreme Court, who summarily denied it, so we could get a court hearing, because we've never gotten a court hearing to have a trial judge or any other judge evaluate whether the DNA is sufficiently exonerating to warrant a new trial. And he describes that the case was going to the Supreme Court, but the governor stayed the execution and appointed the Board of Inquiry. So even though they were taking it to the Supreme Court, if that didn't work, they didn't need the Supreme Court to issue an emergency stay on the execution. And then remember, this is August 25th, 2017, so Kent describes what's happening with this board that Greitens appointed. He says that at this point, the governor had indicated he's going to appoint 5 retired judges to act as a board of inquiry, to hear all of the evidence in the case, and then make a recommendation to him, to Greitens, as to what he ought to do. Kent says, I don't know how fast that's going to happen. We're sort of in uncharted waters. This law has been on the books since the 60s, but it's only been invoked once, and it didn't involve a claim of innocence. It dealt with a mentally ill inmate back in the 90s, so we don't exactly know how this is going to proceed, whether we're going to have a right to appear before them, whether he'll have right to counsel. We do know by statute that it's not going to be a public hearing, and that the recommendation they make is not going to be made public, which is a bit of a concern, because we don't know exactly what the ground rules are going to be for this entire proceeding. So, lack of transparency, and then we're going to find out that because the governor resigned as of 2023, there's no clue what happened with if any report was ever issued. And obviously Greitens wasn't in place to make a decision based on a report, even if there was one. And then lastly, in this Democracy Now! Interview, they touch on the jury profiling a little bit. So Amy asks, you're concerned about the racial bias in the original trial, where there were 11 white jurors and 1 black juror. Why was there just 1 black juror? And Kent describes, because the prosecution, which has been the habit of St. Louis County prosecutors, and particularly in death penalty cases involving African American defendants, they use their preemptory strikes, where they can strike jurors for any reason to remove blacks from the jury. And in most of the capital cases that have come out of that county in the last 15 or 20 years, most of them had all white juries. Marcellus had 1 black juror, and that's just because they didn't have enough strikes to get rid of all of them. But St. Louis County, as everybody may remember, is the same county that we had in the Ferguson police shooting incident a couple of years ago. So there have been racial issues and controversies surrounding the criminal justice system in that county for years. And it sort of came to a head with the Michael Brown shooting. And the prosecutor, Mr. McCulloch, was involved in that and is probably one of the most pro-death penalty prosecutors in the entire state. At a time where the death penalty is waning in popularity and prosecutors aren't seeking it nearly as often, he's an exception. He's never seen a death penalty he didn't like. And then Amy Goodman asks Gibson, did you deliver the news to Marcellus Williams about the stay of execution? And he says, yes, well, I was the second one too. The other lawyer on the case was actually at the prison. I believe that was Lawrence Comp. We'll hear about him later. So he told him in person. And then I told him. I talked to him on the phone a little later. And his reaction is how it's always been. He's very calm and he's a very devout Muslim. And he's basically said all along, quote, fight for my life, but whatever happens, it would be God's will. And we're going to get one other quote. We're going to get a quote from Lawrence Comp in a second on Marcellus Williams' initial reaction. So if we hop over to CNN, we can see some quotes from Lawrence or Larry Comp, and he's relaying as a quote from Marcellus Williams. Defense attorney Larry Comp said that he was ecstatic upon hearing about the stay, and added that he thought Williams felt similarly. He was thoughtful and I believe happy, and asked, where do we go from here? His reaction was the same as mine. Happy for 30 seconds, and then, all right, let's get to work. And remember, this is 2023. This is 6 years and some months after this moment. And they've continued to work, not just fighting for this man's innocence, but to also make sure he isn't executed before they can complete that fight. Also, we have, in a statement, St. Louis County Prosecutor Robert P. McCulloch said he is, quote, confident that any board and the governor, after a full review of all evidence and information, will reach the same conclusion that the jury in several courts have reached over the past 20 years. Now, this bit is interesting because we just heard Kent Gibson say, hey, I've been on this for 12 years trying to get them to look at DNA evidence, and then we finally got it, and then we looked at it, and it fully excludes Marcellus Williams' DNA from the murder weapon, even though there's the presence of an unknown male also on this murder weapon. Now that's important because the exclusion isn't the only thing, and there's also the presence, there is presence of DNA. And it is not Marcellus Williams, and it is not Gale's, and it is not Gale's husband's. And none of these courts have looked at that evidence. There's been no trier of fact to consider this DNA evidence. And in this quote here, the current prosecutor at the time says that we're confident that they're going to do a full review and just come to the same conclusion. Well, that's not a full review then, is it? Now, after the prosecution made this press release, this statement, which I couldn't load it was a 404, it was a link not found when I tried to open it, we do have some more information on what else was said, and it's because the NAACP pushed back against Prosecutor McCulloch's statements. So on August 28th, 2017, we have this article here. And Bob McCulloch says something that really sucks, coming from a prosecutor who's not just meant to find people guilty, they're meant to pursue justice and exonerate the innocents and not prosecute people that are innocent, not allow a conviction of someone to stand if there's evidence that proves they are innocent. Here's what he said. Bob McCulloch defiantly insisted to the Associated Press that there is actually zero possibility, quote, zero possibility, the death row inmate is innocent. And just to show you the website that's linked, it's saying that it's no longer there. But that quote was originally published through some statement to the Washington Post. That certainty has drawn sharp rebuke from the Missouri NAACP. The organization held a press conference this afternoon outside the St. Louis County Courthouse on Clayton, blasting McCulloch. Is it the prosecutor's role to come out and try to defend every conviction that's ever been received? Asked Nimrod Chappell, who's the state chapter president. I think most trial lawyers do their best work in court. I'm not sure what the role of the prosecutor has to make that kind of statement to the community, other than to suppress the desire for justice. Before Greitens' executive order, McCulloch went out of his way to trash the significance of the DNA evidence. In an interview with St. Louis Public Radio, the day of Williams' would-be execution, McCulloch said the conclusions Williams' attorneys were drawing were, quote, flat out wrong, because the DNA evidence was, quote, not of sufficient quantity or quality to identify or exclude anyone. Now I want to pause there. How are you saying that someone is flat out wrong for what they're advocating for? And your reasoning is that the thing they're basing it on is not sufficient quantity or quality to identify or exclude anyone. But your job is to prove beyond reasonable doubt. So I can't reconcile those two statements, that someone else is flat out wrong, but because there's not sufficient certainty. So how can you be certain that someone is flat out wrong if there's not enough to be certain? And this quote kind of sucks because on direct appeal, the response from the court denying Marcellus Williams' request for an appeal, he tried to appeal on multiple grounds. And I noticed that in the decision to reject the appeal, the appeals court pointed out that sufficiency of evidence was not a grounds raised during the appeal. That kind of sucks. And I wondered if that mention was put in there because the appeals court may have been looking for that. Because maybe it would have been a valid grounds that they would have been ready to consider. McCulloch goes on in this interview before the stay was announced. So what he said so far was before the stay was announced. This is to a radio station interview before his execution was set to take place. Because remember, it was like hours away. Marcellus Williams killed her, McCulloch told the radio station. It was a vicious assault. He laid in wait for her. And then, after Greitens issued his executive order that same day, McCulloch doubled down. In an official statement from his office, he said, I am confident that any board and the governor, after a full review of all evidence and information, will reach the same conclusion reached by the jury in the various courts. It's also worth noting that the Missouri Attorney General's office has also defended Williams' guilt, arguing that there is enough non-DNA evidence, meaning not physical, to prove Williams killed Gail while burglarizing her home. While no forensic evidence directly links Williams to the murder, two witnesses. We've heard a little bit about those witnesses. We're going to hear more. Say Williams confessed to them, and several of Gail's personal items were recovered in the trunk of his car. As for McCulloch, it's fairly common to see prosecutors defending criminal convictions during appeals or civil lawsuits. However, during today's press conference, NAACP President Nimrod Chappell said the prosecutor had gone too far with his, quote, zero possibility comment. I mean, yeah, especially if in a radio interview just hours previously, you're talking about how there isn't sufficient evidence to conclude one way or exclude someone one way or the other. But you say zero possibility. And that's a great example of rhetoric versus reality, not matching. Chappell goes on to say, with this case being so important to a human being, to a life, he could have easily just been quiet. But Bob McCulloch chose to make the statement, and by choosing to put things out, he brought us into the conversation. We can't stand by and let you bias the process. And personally, I agree. So, just for some context there, in 2018, Bob McCulloch lost his bid for re-election in the Democratic primary to reformist challenger Wesley Bell by a 13.24% margin. And a reminder, there is a link in the description if you want to sign the petition to stop the execution of Marcellus Williams. In just a second, we're going to do a quick speed through of the 5 reasons that the Innocence Project and others are, bullet pointing for easy information consumption that he's innocent. But before we do that, I want to talk about something we mentioned earlier, the Postman's Gambit, and striking African-American jurors by any grounds that they can find that won't look like a racial reason. And we had heard from Gibson that one of the jurors stricken in the Marcellus Williams trial was stricken because he was a post office worker. And this is a thing. This is coined the Postman's Gambit. It's something that a prosecutor even bragged about using all the time to strike certain people from juries. So I'll link to this article from NPR. This article really focuses on Missouri specifically and how the racial composition of juries is a matter of life or death when it comes to capital murder trials. So it starts off by discussing the case of Herbert Smalls, and he was represented by Karen Kraft, a public defender who has done some commentary about preemptory strikes and how judges kind of don't really look into them too much. For Kraft's client, Herbert Smalls, who was sentenced to death by an all-white jury in 1992 and later executed, Prosecutor Dean Waldemar struck the final black juror from the pool. Challenged by defense attorneys, he claimed he had a policy against postal workers. It's been my experience in the 9 years that I've been a prosecutor that I treat people who work as mail sorters and as mail carriers for the U.S. Postal Service with great suspicion. In my experience, in many of the trials that I've had, they're very disgruntled, unhappy people with the system and make every effort to strike back. NPR's writer goes on to say, maybe that was the reason, or maybe it was the fact that the majority of postal workers in St. Louis County are black. Says Kraft, that was typical. Waldemar's technique earned him infamy in activist circles, which dubbed it the Postman's Gambit. But it didn't leave a mark on Waldemar's name. He's now a St. Louis County judge. So in this article from St. Louis Mag, we see a little bit more about Karen Kraft going toe-to-toe with Dean Waldemar about one of these strikes in the Smalls case. According to trial transcripts from the Smalls case, Waldemar and Kraft fought hard over one of these strikes. The prosecutor wanted to remove the last African American, a woman who sorted mail at Monsanto, but Kraft challenged the strike, claiming that it was racially motivated and citing the Batson decision. The issue was bounced back to Waldemar, and he was given a chance to explain, which is a normal process, and maybe one that should be revisited, but that's how it goes. It's been my experience in the 9 years that I've been a prosecutor that I treat people who work as mail sorters and as mail carriers for the U.S. Postal Office with great suspicion. In my experience, in many of the trials that I've had, they are very disgruntled, unhappy people with the system and make every effort to strike back. In addition, he said the potential juror had glared at him, and her manner of dress, wearing a beret one day and a baseball cap with sequins on it the next, also gave him pause. I just felt she wouldn't be a good state juror. Kraft wasn't buying it. She said she didn't detect, quote, any type of attitude from the woman. She labeled his reasons pretextual, in other words, a cover story to conceal his true motive, assembling an all-white jury. Once a strike is challenged, it is up to the trial judge to decide whether it was proper, but St. Louis County Circuit Judge William Corrigan made it clear that he didn't relish his role. Quote, I don't know what constitutes black, he said. Quote, years ago, they used to say 1 drop of blood constitutes black. Can somebody enlighten me of what black is? Corrigan said that it should be up to the defense to first prove who is black and who isn't. Nevertheless, he said, he was denying the challenge. The strike was allowed to stand, the potential juror was removed from the panel, and the case proceeded to trial. The jury convicted Smalls of first-degree murder and imposed the death penalty. Years of appeals would follow. One of those appeals, but by no means the last, ended up before the Missouri Supreme Court in 2002. Although the court upheld the strike and the conviction, Missouri Supreme Court Chief Justice Michael Wolff wrote a concurring opinion urging a reduction in the number of preemptory strikes allowed during jury selection. But back to the postal worker thing. Chris Goki, a former prosecutor with the St. Louis Circuit Attorney's Office, who now handles both criminal defense and civil cases with his own law firm, J. Christian Goki, says that in criminal cases, lawyers also make occupational generalizations. According to Goki, a prosecutor may strike postal workers by arguing, they are very unfair to the state because of the amount of surveillance that takes place in postal facilities. Postal workers tend to want a videotape of a crime before they are willing to convict. So, and again, he's saying that this is a prosecutorial preference. He now works in criminal defense and civil defense. Social workers might be removed because of a fear that they can't be fair when it comes to punishment. Even firefighters have been taken off panels by prosecutors, says Goki, when a police officer will testify in the case. The reasoning? Police officers and firefighters don't get along. So that's a little overview of the Postman's Gambit, which came into play with Marcellus Williams' trial, where a black postal worker was stricken from the jury. We have down here that one of the reasons was that he was a postal worker, but we also have that his earrings and clothing indicated that he was, quote, trying to be different and was, quote, liberal, which a prosecutor probably doesn't want in a death penalty case. The appeals court says that striking a prospective juror based upon clothing and attire does not reflect an inherent racial bias, Second, the prosecutor stated that the jurors' demeanor and appearance were similar to Williams. But the appeals court says that these reasons are not inherently race-based and said as much the same about the postal worker mentioned. Number 65. The reason the state gave was that because he was not definite enough on whether he could consider the death penalty and because he was court-martialed while in the military for stealing money. Both of these are reasons that are race-neutral and are supported by the record. And then Juror 72. The state says they struck him because he was fired from his job for physically attacking a fellow employee and because he appeared upset after other jurors laughed at him as he answered the prosecutor's questions concerning that incident. And the appeals court maintains that that's a racially neutral explanation for the striking. We know that the appeal wasn't successful, but that was the one of the arguments on appeal about jury strikes, preemptory strikes. So the appeals court did not agree with that grounds. And very interesting that in one of the concurring opinions, we did have the state Supreme Court Justice Wolf say that, maybe we should reevaluate the process of preemptory strikes, maybe reduce the number that the prosecution gets. Maybe that would be one good solution. Maybe it would hurt in some other cases. Maybe I don't really know, but that was 2002. I'm not sure there's been much reform. But anyway, getting back to the facts of the case and Marcellus Williams. If we move to June 14th, 2018, so just shy of 1 year after the execution was stayed by Governor Eric Greitens and that board was formed, Governor resigns and now Marcellus Williams' fate is uncertain. Greitens issued, I think, 5 pardons when he left office in June, but Williams was not one of them. The board that was formed to review Williams' case is now canceled. And when they asked the new governor, Michael Parson, will the board meet? Will they make a recommendation to you, and what will you do then? Parson says, well, I would assume they would meet. I heard they're not going to. So I think once they make a recommendation, if they do meet, then we'll discuss that at that time. I'm sorry, but this sounds like no, that's done in the water. And we also have the Missouri Attorney General's office still maintaining that Williams is guilty. Though Williams was not linked to the murder weapon, police found Gail's clothing and her husband's computer in Williams' car. We'll continue to defend the judgment of the jury and the many courts that have carefully reviewed Mr. Williams' case over 16 years. And then there's a quote from the family, from Gail's family, that while we understand that Williams' sentencing fits a troubling pattern of racial disparity in the death penalty and that a case is serious enough to warrant careful scrutiny, we would ask those on all sides to recognize that for the family, this is not policy, it is pain. So, fair enough. So now remember, the article we just looked at and those statements were from 2018, when Governor Parson is like, hey, I heard they're not going to meet, but if they do meet, well, I don't know. So we fast forward to 2023. You can see down here that this is an executive order that was signed on the 29th day of June, 2023. Whereas Executive Order 1720 was issued on August 22nd, 2017, establishing a board of inquiry to assist the governor in determining if Marcellus Williams should receive clemency from a sentence of death. And whereas, the board shall make a report and recommendation to the governor. And whereas all information gathered by the board shall be held by the governor in strict confidence, I, Michael Parson, Governor of Missouri, do hereby rescind Executive Order 1720, thereby dissolving the board of inquiry established herein, and remove any legal impediments to the lawful execution of Marcellus Williams created by Executive Order 1720, including the order staying the execution. So 5 years go by, almost 5 years, because this is June. We had August 2018. He said, hey, I'm here now. I'm a governor now. I don't think this board's going to meet again. I think the board's canceled. I don't know. 5 years later, he issues this executive order officially dissolving the board that was already canceled and iterating that any legal impediments to the lawful execution of Marcellus Williams, including the stay on the execution, are rescinded, dissolved, gone, kaput, moot. Parson released a press statement in conjunction with this executive order and said, this board was established nearly 6 years ago, and it is time to move forward. We could stall and delay for another 6 years, deferring justice, leaving a victim's family in limbo, and solving nothing. This administration won't do that. Withdrawing the order allows the process to proceed within the judicial system, and once the due process of law has been exhausted, everyone will receive certainty. Now, it does reiterate that all information and documents gathered by the Board of Inquiry and any reports and recommendations to the governor are closed records under Section 552.070. But we have this verbiage here. We could stall and delay another 6 years. And we also have this verbiage that once due process of law is exhausted, everyone will receive certainty. So there is some acknowledgement that there is no certainty. But it seems to me that we could stall and delay for another 6 years means that there was no report. This board was canceled 5 years ago. They never met. They never issued a report. That basically all we got was Greitens was able to stay the execution of Marcellus Williams. But the reason for the stay, this board, for someone to come along and look at this DNA evidence, to consider this DNA evidence that completely, definitively certainly excludes Marcellus Williams' DNA from the knife handle, despite there being the presence of a male's DNA, of someone that actually held that knife that was not Gail, and that was not Gail's husband. That part of Greitens' move, I think it's safe to conclude that this board never made a report. And even if they did, we wouldn't have any transparency into what they gathered, what they recommended. We're just getting a statement from Mike Parsons saying, it's time to move forward. Take it back to the judicial system, which has refused to look at this DNA evidence. So, we are now in 2023. And we've looked at a lot of the background context on the politics, on the pressure from social media, on the rhetoric, broader level things about jury selection and Missouri prosecution. Now we're going to dive into the case for Marcellus Williams. And we're going to start with the summary of 5 reasons that Marcellus Williams is innocent. And then we're going to get into 2 readings. One is something that's favorable to a prosecution, and it reviews the case and some of the, judicial due process means. And then we'll get into a petition from 2017 that Gibson and Comp prepared to file to the U.S. Supreme Court, which is a favorable to the defense style reading of the statement of facts of the case, as well as an insistence on, proper due process and pursuit of justice for not just Marcellus Williams, but any convicted persons that is maintaining their innocence. We're going to do a deep dive into those 2 different documents because they're both going to give us a peek at some important parts of the transcript, the record from the trial, the evidence and the reasoning used by the trial prosecution and trial defense, and then what the judicial process, as far as the appeal, the motions for post-conviction relief, writs for habeas corpus. It'll give us a nice timeline of what's been going on for the 2.5 decades since this murder occurred and this man was, in my opinion, wrongfully convicted. And remember, you can hop over using the link in the description to sign the petition to stop the execution of Marcellus Williams. You can also share it to help more people find out about it. Remember that this petition reached 200,000 signatures the first time when Governor Greitens was like, hey, you know what? I'm going to order a stay on this man's execution just hours before we wouldn't have had an opportunity to change our minds and make sure we were sure before we commit the execution of this man. So let's do a top-level summary. This is from the Innocence Project, and you can see that this was updated on December 12th, 2023. In August 2023, the Innocence Project, the Midwest Innocence Project, and Brian Cave, Leighton Paisner, that's actually a huge law firm, sued Missouri Governor Mike Parson on behalf of Marcellus Williams for dissolving the Board of Inquiry investigating Mr. Williams' innocence, claiming and lifting the stay of his execution. Governor Parson dissolved the board before it completed its investigation. Okay, so there, boom. Governor Parson dissolved the board before it completed its investigation. So now I feel okay reading that into the language where, oh, we're going to move on. We don't want to wait. Yeah, so they didn't seem to have completed their investigation or provide him with a report and recommendation, as is required by law. The governor filed a motion to dismiss the lawsuit, but Cole County trial judge Cotton Walker denied the motion. Governor Parson then appealed Judge Walker's denial to the Missouri Supreme Court, which stayed Judge Walker's decision. If St. Louis County Attorney Wesley Bill doesn't intervene, the Missouri Supreme Court could dismiss Mr. Williams' lawsuit and set an execution date for Mr. Williams at any time. So this is the guy that won by that 13.54% margin over former prosecutor Bob McCulloch in re-election. Mr. Williams, 53, has spent 24 years of his life on death row for a murder that DNA evidence proves someone else committed. In 2017, then Governor Eric Greitens stayed his execution minutes before it was scheduled to take place. Damn, I didn't know it was minutes. I've been saying hours this whole video. That's insane. Can you imagine, like, you've got to have some type of lasting stress from being seconds away from being lethally injected. And then it says in 1998, Felicia Gale, a former St. Louis Post-Dispatch reporter in St. Louis, was stabbed to death 16 times in her own home. I think she was stabbed 16 times in the neck, but was stabbed 43 times. Maybe I have it incorrect. We'll see that again as we go along, but I'm pretty sure I've read it more than once that she was stabbed like 40-something times and multiple times in the neck, and that's not insignificant in general, even like a one-off case, because stabbing someone that many times, you can kind of infer, deduce certain things from that type of stabbing. But additionally, there were other murders in close proximity at the same time frame of Gale's murder that had a similar stab wound, where this kitchen knife, the victim gets stabbed like 40 times, the kitchen knife is left in the victim in the neck, and then the person is found later. The dead person is found later. You know, details like that are important for a forensic investigation, but it's also important because it could be an MO of other murders, a possible serial killer that was happening at the time. So I'm pretty sure she was stabbed 16 times in the neck, but she was stabbed 43 times total. And small detail, but, you know, just because I'm reading this out loud on the stream, I want to state that explicitly, that I'm pretty sure it was 16 times in the neck. Now, the reason that the presence of the DNA on the knife is so important is because the state is arguing that the new DNA evidence does not come close to showing if Williams is actually innocent. It would be unsurprising if Williams, who wore a coat according to witness testimony, not anything that Williams has said, it would be unsurprising if Williams, who wore a coat from the crime scene to cover his bloody shirt, wore gloves when he committed the burglary and the murder. The problem with that is that there's definitively DNA of a male on this knife that doesn't match Gale's husband, doesn't match Gale, who's a female. So even though this statement is trying to clean up the exclusion of Marcellus Williams' DNA, it doesn't rule out the presence or significance of another person, an unknown, unidentified person's DNA being on the murder weapon. So 2 years later, Mr. Williams was convicted of the first-degree murder, robbery, and burglary of Miss Gale. His conviction primarily relied upon the inconsistent testimonies of two incentivized witnesses with no concrete physical evidence linking him to the crime scene. One of the witnesses, Henry Cole, only reached out to police 10 months after the crime when all leads had run cold and he saw an opportunity to secure a deal for himself on his own cases, plus a reward. He told investigators that Mr. Williams had admitted to the crime while they were both in prison, and he would testify to that if they helped him in return. In 2016, testing of DNA samples taken from the murder weapon excluded Mr. Williams. I think it was 2015, but I think that was 2015. In 2015 or 16, testing of DNA samples taken from the murder weapon excluded Mr. Williams as a contributor, proving he did not commit the crime and contradicting the testimony used to convict him. Though no new execution date has been set yet, one could be scheduled as early as any time. And Mr. Williams' life remains at stake for a crime he did not commit. So again, you can hop over if you want to sign or share the petition. The link is in the description. Here's what you need to know about this case. 1. Mr. Williams has been excluded as the source of the DNA found on the murder weapon. On August 11, 1998, Dr. Daniel Pickus came home from work around 8 p.m. to find his wife, Miss Gale, dead at the bottom of the stairs. Yeah, so I'm just double checking. You know, if I see 43 times, we have these reports all over, so that's inconsistent. I mean, I think it's in some of the statement of facts that we're going to read. But here we do see, again, she had been stabbed 16 times, and one of the kitchen knives was protruding from her neck. I do believe it was 16 times she was stabbed above the torso in the neck area, 43 times total anywhere on her body. In 2016, post-conviction DNA testing conducted on the handle of that knife detected the presence of male DNA and excluded Mr. Williams as the source. 2, and if you follow me on X, you've heard me say this, no court has reviewed the exculpatory DNA evidence. In 2017, then Missouri Governor Eric Greitens stayed Mr. Williams' execution based on the DNA results from the knife handle. However, no court has been willing to hear this evidence, which has been reviewed and analyzed by 3 renowned DNA experts who have all concluded that Mr. Williams is not the source of the DNA on the knife handle. And remember, there is DNA of an unknown male on that knife handle. It's not just the absence of DNA. There's DNA that has not been identified or tied to anyone. The DNA wasn't even run through the SCOTUS system, the national database, to try to find a match, but it's definitively excluding Marcellus Williams as a contributor. It's not just the absence in totality of DNA of a suspect. 3. The prosecution's case against Mr. Williams was based entirely on unreliable testimony of 2 incentivized witnesses. And this is a summary. It's going to be crazy in the summary. It gets crazier the more you look into the case, some of the case details, some of the case filings, the statement of facts. Here's a short summary. The case against Mr. Williams relied heavily on testimony from 2 people, Mr. Cole, a prison informant, and Mr. Williams' ex-girlfriend, Laura Asaro. However, the credibility of both these testimonies has significant grounds for skepticism, much of which the jury was not aware of. Mr. Cole, known for his dishonesty by his family members, had a potential motive to fabricate or exaggerate his claim that Mr. Williams confessed to him while they were both incarcerated. Mr. Cole initially refused to participate as a witness in Ms. Gale's case until he was promised payment, and then made it clear in the 2001 deposition that he would not have come forward if it had not been for the $5,000 he was given by prosecutors. Notably, several details in his testimony were strikingly similar to the information that had been published in newspapers about the murder, suggesting he may have been fed this information directly or indirectly. Prior to the deposition, Mr. Cole had pled guilty in 1996 to armed robbery of a bank and was sentenced to 4 years of probation with 10 years of prison suspended. Although he violated parole 6 times, the court never imposed the suspended prison sentence on him. Ms. Asaro, too, the 2-week girlfriend, had a history of deception and had faced solicitation charges when police initially approached her about the case in November 1999. Remember, the murder happened in 1998. So, fast forward to November 1999, the police are approaching Asaro. She had worked with the police before and had testified against Mr. Williams in a previous trial. She even lied under oath in her recorded deposition regarding her arrest history. At some stage, police had considered charging her as an accomplice in the crime. Ms. Asaro also mentioned to her neighbor that she was receiving money for her testimony against Mr. Williams. Further adding to the doubt, the narratives from Mr. Cole and Ms. Asaro were significantly different and didn't match the crime scene evidence. For example, Ms. Asaro testified that Mr. Williams had scratch marks on him, but there was no foreign DNA present under Ms. Gale's fingernails. The only evidence connecting Mr. Williams to Ms. Gale's murder was the testimony of Mr. Cole and Ms. Asaro. According to the National Registry of Exonerations, incentivized witness testimony has contributed to 14% of death penalty cases that later led to an exoneration. DNA exoneration. The 2 incentivized witnesses in this case were motivated by the reward money and favorable treatment in their own criminal cases. Now, they don't mention it here, but there was also a $10,000 reward issued by Gale's husband that Mr. Cole explicitly mentioned, came on and was displayed on the TV while he was in jail sitting next to Mr. Williams. And while this reward's on the screen, he says that Mr. Williams was just like, I killed her. And then Asaro says that, yeah, he told me he killed her. And then the prosecution in closing argues to the jury, imagine you're Miss Asaro and Mr. Williams is choking you out, telling you that if you tell anybody, he'll kill you and your family and the people you know. So it's like, the grounds of this case are that he voluntarily told Mr. Cole and Miss Asaro, he just spit it out to them. But then was also like, if you ever tell somebody. Do you have questions at this point from the summary? Because I have questions. The 2 incentivized witnesses in this case were motivated by the reward money and favorable treatment in their own criminal cases. Well, not just their own. Asaro was almost an accomplice in a other burglary case. That must have been a crazy 2-3-week relationship. 4. No scientific or eyewitness evidence or motive connects Mr. Williams to the murder. Even though the murder occurred in the middle of the day and the neighbors were out and about, no one saw Mr. Williams anywhere near Miss Gale's house. Police found bloody shoe prints at the scene and concluded that they did not belong to Mr. Williams. So think of all those statements from the prosecutor. We're sure, even though the DNA evidence is coming out and exists, we have so much non-DNA evidence that shows that Mr. Williams did it. But then what is this? Police found bloody shoe prints at the scene and concluded that they did not belong to Mr. Williams. They also collected and tested biological evidence from the scene and determined that none of this biological evidence belonged to Mr. Williams. That's like head hairs and pubic hairs that they collected. We'll go over it in detail, but if you don't make it that far, they also said that the footprints did not belong to any medical examiners that showed up. So the bloody shoe print could reasonably be from the actual suspect they should have been looking for, and they do not match Mr. Williams. Number 5. In 2017, then Governor Greitens stayed Mr. Williams' execution because of the powerful exculpatory DNA results. In August 2017, then Governor Missouri Eric Greitens intervened just hours or minutes, I don't know, before Mr. Williams' scheduled execution, signing an executive order postponing the date. This was not the first time Mr. Williams' execution had been put on hold. Governor Greitens assembled a board of inquiry. They were tasked with reviewing the newly found DNA evidence and other pertinent evidence to which the jury may have not had access. The order granted the board the authority to demand testimony and information and required it to keep its proceedings and all collected information confidential. The executive order clarified that the execution would be postponed until the governor had decided whether Mr. Williams would be granted mercy based on the board's findings. However, it is unclear if any report has ever been issued. Mr. Williams' legal team never received a report, and Governor Parson dissolved the board without giving any indication that he had received a recommendation, and if so, what it was. Which is why that press statement is crazy. Because it's just kind of like, well, we don't want to wait any longer. Let's just cancel this board. We're dissolving it officially. There's no answer. Deal with it. Mr. Williams' case is riddled with unreliable, incentivized testimonies and a complete absence of physical evidence linking him to the crime scene. The lack of consideration by any court of the exculpatory DNA evidence, which indisputably excluded Mr. Williams as a contributor, calls into question the validity of his conviction. Despite the evidence pointing to his innocence, Mr. Williams remains on death row more than 2 decades after his initial arrest. With the weight of this new evidence and the unreliability of the witnesses who testified against Mr. Williams, his conviction must be reevaluated to ensure that justice is truly served. His legal team, comprised of dedicated professionals from the Innocence Project, the Midwest Innocence Project, and Brian Cave, and attorneys Larry Comp and Kent Gibson, continues to fight to stop this execution and for his exoneration, hoping that justice will eventually prevail. Now, there's so much going on in this case. It's been going on for 2.5 decades. You know, there's direct appeals, there's motion for post-conviction relief, there's social advocacy, there were writs filed to the Supreme Court of the United States, the state Supreme Court. There was one appeal that was granted by a higher court in Missouri. It was remanded back to the court, and then the judge was like, well, this isn't really the greatest avenue to evaluate this, so we're just going to sit on it and deny this appeal request, even though you've sent it back to us. I've put links to a bunch of the different pieces of this puzzle in the scratch pad I used doing my own research on this case. You are welcome to visit that and grab links. It is not the prettiest document, but it's there and it could save you some time in searching for working links that still exist today in 2023 and 2024 without having to start from ground zero research on your own. And we're going to get through 2 readings that I think do great summaries of the statement of facts and give us some insight on, you know, the judicial rulings as a pattern when it mattered in this case, and then also the broader level precedent and case law that the Innocence Project is bringing into its appeal, at least to the Supreme Court, which never had to be heard because Governor Greitens issued the stay. But it's becoming relevant again now that there is no longer a stay in place and there was no determination made from this board that was created. So we're going to look at those 2 things because it'll help us deep dive into something that affirmed the judgment and the case argued by the prosecution, and something that pokes holes in it without us having to deep dive into everything. It was a quick timeline of how this stuff moved through, you know, appeals courts and the post-conviction motions for relief, just so you get the picture of how long this fight has gone on and what a fight looks like. For direct appeal, the Supreme Court of Missouri affirmed the judgment, the guilty verdict, on January 14th, 2003. It says here, the judgment is affirmed. On March 4th, 2003, the Supreme Court of Missouri affirmed the sentencing judgment. So Williams was sentenced to death. The judgment is affirmed. Because remember, in trials like this, there's a guilt phase and then a penalty phase. So guilt is, did they actually do this stuff? This is our argument for that. Make your verdict. And then sentencing. There has to be a judgment on what the sentencing should be to fit what they're guilty of. On August 30th, 2005, Williams asked for a rehearing, and he filed for post-conviction relief under Rule 2915, which relates to ineffective assistance of counsel. But the court affirmed the judgment and denied the motion and denied the rehearing. On August 29th, 2006, Williams filed a habeas corpus petition that raised 13 grounds for relief. He was asking for, new evidentiary hearings, this new DNA evidence that came about. And you can see, if you see here, this is filed against Donald Roper. That was probably the warden of wherever Marcellus Williams was being held in custody. Basically, the petition is to produce release from holding, habeas corpus, you're holding this body. But the petition relates to unlawful imprisonment, and that's why the petitioner, Marcellus Williams, is here requesting motion for discovery to compel the state to conduct further DNA testing, a motion for evidentiary hearings. But the court denied the motion for further DNA testing, for discovery, and for evidentiary hearing. And this was on March 29th, 2007. It was filed on March 30th, 2007. And this was filed by Rodney Sipple. Yeah, Rodney Sipple, district judge. And then back in the district court, March 25th, 2010, Rodney Sipple finds that Williams' trial counsel was constitutionally ineffective for failing to thoroughly investigate Williams' background in search of mitigating evidence for the sentencing phase, the penalty phase. And he cites the Supreme Court decision in Wiggins v. Smith. And then on June 16th, Rodney Sipple had to issue this memorandum in order because the state tried to argue against, this granting of habeas corpus relief on that one claim of ineffective counsel at the penalty phase. And Sipple's like, no, the state, you're relying on a rule that doesn't apply here, and you filed it late. So, and not only that, but not only did you fail to request it, you actually actively opposed such an evidentiary hearing. Because remember, we've seen already in this quick little timeline summary that Williams keeps requesting evidentiary hearings, and the state keeps fighting it, and the courts so far have agreed. And it's in the record, so it's cited here. In addition, the affidavit was part of the record on appeal before the Missouri Supreme Court, and there is no evidence that the court refused to consider it. Accordingly, it's hereby ordered that the respondent's motion to alter or amend the judgment, the respondent here is the state, is denied. So, Williams sort of had one small win that ended up going nowhere, but it was something. He was granted habeas relief only on the claim of ineffective assistance of counsel at the penalty phase, because they didn't go and look and say, hey, is there something that is wrong and treatable with this person that, the death penalty should be off the table, because the death penalty should be reserved for people that can't be treated, can't be rehabilitated, can't be dealt with in any other way, for lack of a better way to put that. And the defense counsel was like, well, we didn't have time to investigate that stuff. I was working on another capital murder trial at the time. And since there was no investigation, at least as it pertains to the penalty phase of the trial, the court was like, yeah, it's a little bit ineffective assistance of counsel for that one part of trial. And that small win comes to a halt because of a reversal on September 18th, 2012. Because the state appealed this grant for relief, and the circuit court agreed and reversed this relief that was granted in favor of the state's argument. Judge Malloy did dissent on this reversal because he disagreed with their determination that no prejudice occurred. This reversal was, majority vote of 2 people in favor of the reversal, and then one dissenting opinion that was like, no, I disagree with this on certain grounds. And in reading this, there was one detail that jumped out that I think is important. In weighing this decision, it was discussed that, even if Williams was able to present this mitigating evidence during the penalty phase, the state court could have just came in and questioned the weight of the proposed mitigating evidence. So, first, any testimony from Williams would be susceptible to impeachment. In a deposition during state post-conviction review, Williams acknowledged that he had lied under oath in 1987 in order to secure a favorable plea agreement. When asked if he would lie under oath when it suits him, he responded, I mean, you should know better than me. Now, the reason that's important to me is because a plea deal is being used to deny further requests for post-conviction relief on a different judgment, on a different conviction. So it's like no matter the circumstances that led to the plea deal, the fact that there's a plea deal in place is now being used to suggest you're impeachable, you're not credible. Now that you've taken this plea deal, you can't come along and try to fight for your innocence on a totally separate conviction later. That's kind of the point A to Z jumping that I'm seeing with that detail. So yeah, that one little grant of relief was reversed. The dissenting opinion argued that the majority opinion failed and misaddressed the reasonableness of prejudice in terms of the failure to investigate mitigating factors to inform not just trial strategy overall, but particularly through the penalty phase. Amnesty International has also commented on the appeals. Marcellus Williams' appeal lawyers have challenged the credibility of the informant witnesses, whether the prosecution withheld information about them that could have been used by the defense, and whether the defense had failed to investigate them. Limited pretrial DNA testing of evidence from the crime did not match Marcellus Williams' DNA, and his appeal lawyers have sought to have further DNA testing, arguing that it could reveal the identity of the real killer. In 2016, DNA testing was conducted on the handle of the knife used in the murder. According to the tester, a DNA profile sufficient to conclusively exclude Marcellus Williams as the contributor could not be developed. Another DNA expert retained by the lawyers concluded that Williams could not have contributed to the detected profile, and the most reasonable explanation for the profile detected on the knife is that Marcellus Williams is not a contributor. The lawyers have also sought to obtain evidence and records from an unsolved murder of a woman who was killed in an adjoining suburb of St. Louis a month before Felicia Gale died. The similarities in the crimes led an investigator to opine that the murders were the work of a serial killer. So in 2010, a federal judge ordered that Marcellus Williams receive a new sentencing, having found that his trial lawyer had failed to present any mitigating evidence of how Williams was subjected to brutally violent physical abuse by family members. He was a victim of sexual abuse, his family condoned and encouraged criminal behavior, he came from an impoverished household, and he was exposed to guns, drugs, and alcohol at a young age. In 2004, a psychologist retained by the appeal lawyers diagnosed Marcellus Williams, among other things, with post-traumatic stress disorder, the symptoms of which were all ignored and left unabated and untreated for years. In 2012, the U.S. Court of Appeals for the Eighth Circuit reversed the ruling by 2 votes to 1. The dissenting judge strongly disagreed with the majority view that under the differential amount of U.S. law for federal review of state court decisions, we must defer to the Missouri Supreme Court's decision that Williams was not prejudiced by his lawyer's failure. The judge accused the majority of an unreasonable deference to an unreasonable strategy based on unreasonable investigation, which ignored the trial lawyer's own admission during the appeal that his decision to not investigate his client's background was not strategic as the majority suggested, but was because he, quote, ran out of time due to the fact that he had been involved in another capital murder trial at the time. The judge overseeing the Marcellus Williams trial had denied the defense request for a delay, and that if he had had the mitigating evidence, he would have presented it to the jury. Now, if you want to take a look at Greg Hampikian, if you want to look at his DNA report that he ended up submitting in 2016, I linked to that in my scratch pad. Just do a search for DNA report and you'll get to that link. My scratch pad is like 20 pages long, so definitely Control F or Command F to find the phrase DNA space report. If you want to take a look at this here. I know this is so much information. We're going to get into, it's less than 16 pages and I'm only going to read the statement of facts. It's coming from the 2007 from Williams versus Roper, so the writ of habeas corpus. It's coming from that memorandum and order where the court denied the motion for further DNA testing, discovery, and evidentiary hearings. We're going to take a peek at the factual background used in that because it will give us a perspective on, an affirmation of the prosecution's layout theory of the case, what happened at trial, what argument they made at trial. We'll do that quickly, and then we're going to jump over to the petition that Lawrence Comp and Kent Gibson submitted to the Supreme Court of the United States. There's some really compelling information on the statement of facts in this case that the jury was not able to hear, and also some really powerful arguments as far as the Supreme Court. Okay, so let's jump into factual background, and remember, this is coming from 2007. This is coming from the district court in their memorandum and order denying Williams' motion for further DNA testing, discovery, and an evidentiary hearing. The reason I wanted to read this factual background is, 1, it's publicly accessible. 2, It summarizes the prosecution's approach in the trial. So let's jump in. Factual background. The following statement of background facts is taken from the opinions of Missouri Supreme Court on direct appeal and on appeal from the denial of post-conviction relief. According to evidence presented by the prosecution on August 11, 1998, Petitioner drove his grandfather's car to a bus stop, and then he caught a bus to University City, Missouri. Petitioner burglarized the home of Felicia Gale and fatally stabbed her. Petitioner washed off and took a jacket to conceal his bloody shirt. He took Gale's purse, containing, among other things, a ruler. Now, pause. Petitioner washed off and took a jacket to conceal his bloody shirt. But we're going to hear about bloody boot prints that did not belong to him, and did not belong to any medics at the scene, and did not belong to the husband. He took Gale's purse, containing, among other things, a ruler with her employer's name on it, and a calculator, and her husband's laptop computer. Petitioner returned to the bus stop, retrieved the car, and then picked up his girlfriend, Laura Asaro. Asaro testified at trial that Petitioner was wearing a jacket despite the summer heat. When Petitioner removed the jacket, she noticed that his shirt was bloody and that he had scratches on his neck. Petitioner claimed that he had been in a fight. She also noticed a laptop computer in the car. She saw Petitioner place the clothes in his backpack and throw the backpack into a storm sewer. And it's worth noting that in anything that I've read here, I don't see any description anywhere that they went and investigated and looked and recovered or tried to recover this backpack, this jacket, these bloody clothes. Asaro testified that the next day, while retrieving some of her clothing from the trunk of the car, she found a purse, which contained Gale's state identification card, a coin purse, and several grocery coupons. Asaro confronted Petitioner about the items. According to Asaro, Petitioner admitted the purse belonged to a woman he had killed. He told her that he had broken into the house, waited for the woman to come out of the shower, and stabbed her in the arm and the neck. Petitioner threatened to kill Asaro, her children, and her mother if she told anyone. A few days later, Asaro discovered a calculator and a ruler in the car. These items were identified as belonging to Gale. And remember, everything we're reading right now is coming from what the prosecution argued at trial, or somewhere on the record. On August 31, 1998, Petitioner was arrested on unrelated charges and incarcerated in the city workhouse. At this point, no arrests had been made in the Gale case, and Petitioner was not a suspect. Henry Cole testified at trial that, from April until June 1999, he and Petitioner were in the workhouse together, and that in May 1999, Petitioner confessed to the Gale murder. Cole was released from jail in June 1999 and told the University City Police that Petitioner had admitted to killing Gale, including details that had not been publicly reported. In November 1999, Asaro told University City Police that Petitioner had admitted to her that he killed Gale. The police searched the car that Petitioner had driven on the day of the murder with the consent of Petitioner's grandfather, the owner of the car, and found Gale's ruler and calculator in the trunk. The police also recovered a laptop computer from Glenn Roberts, an acquaintance of Petitioner who had bought the laptop from Petitioner after the murder. The laptop computer was identified as the victim's husband's computer. Petitioner was tried and convicted of 1 count of first-degree murder, first-degree burglary, first-degree robbery, and 2 counts of armed criminal action. Petitioner was sentenced to death on the murder count. He was also sentenced to 30 years imprisonment, each on the burglary and armed criminal action counts, and life imprisonment on the robbery count, to be served consecutively. And here, you might have heard me mention earlier in this video, Petitioner appealed, raising issues challenging evidentiary rulings, voir dire, instructions, and closing argument. He did not challenge the sufficiency of the evidence. In a lengthy opinion, the state Supreme Court held that the trial court did not err in refusing to allow defense counsel to elicit Glenn Roberts' hearsay testimony that Petitioner had told Roberts that he, the petitioner, was selling the laptop computer on behalf of Laura Asaro. Through Roberts' testimony, the prosecution established the fact that the petitioner was in possession of the laptop and that he sold it to Roberts shortly after Gale's murder. Because the prosecutor did not ask Roberts about any statements that the petitioner had made to him, the state Supreme Court ruled that the rule of completeness did not apply. The state Supreme Court noted that the petitioner was not precluded from showing that Laura Asaro had possessed the laptop. 2 witnesses testified that they saw Laura Asaro with a laptop computer during the summer of 1998. The state Supreme Court also held that the trial court did not abuse its discretion by denying the defense objection to the admission of evidence of petitioner's attempt to escape from the city workhouse. Evidence showed that the petitioner attempted to escape about 3 weeks after he had been indicted on multiple charges, and that on the day of the escape, petitioner had been sentenced to 20 years in prison on unrelated charges, and that during the escape attempt, petitioner had assaulted a guard. So the jury got to see all that during sentencing, during the penalty phase. And then there's some other key detail information here about post-conviction relief and the decisions made there, which it was, denied. Petitioner filed a timely pro se motion for post-conviction relief in state court. Appointed counsel filed an amended motion. The motions court held an evidentiary hearing only on the claim that trial counsel was ineffective for failing to advise petitioner of his right to testify during the penalty phase. The state Supreme Court affirmed the denial of post-conviction relief and denied the motion for rehearing on August 30th, 2005. First, petitioner argued that Cole and Asaro had extensive criminal records and histories of mental illness that significantly undermined their reliability and credibility. Petitioner claimed that the state failed to disclose criminal and mental health records that the defense could have used to effectively impeach Cole and Asaro, which was a Brady violation. The motions court held that the claim was refuted by the record, that is, more than a year before trial, the prosecutor notified defense counsel that Cole and Asaro had made videotaped statements and that those statements were available for viewing. According to the prosecution, Cole and Asaro feared reprisal by the petitioner and had not been in regular contact with police or prosecutors. Well, we do know, Cole had a suspended prison sentence and violated his parole 6 times in that short period, so he's got to be in regular contact with somebody that relates to benefits conferred to him, so that's interesting, but okay. In March 2001, more than 3 months before trial, the prosecutor provided defense counsel with the videotaped statements and the police reports about them. The state Supreme Court noted that the motions court had found that the prosecution did not conceal the statements of Cole or Asaro or their locations. And then another thing that I think is worth pointing out is this mention here that petitioner, that's Marcellus Williams, alleged that the state manufactured evidence against him by offering to assist 2 other men with their ongoing criminal prosecutions if they would testify against the petitioner. Neither man testified against petitioner at trial. Petitioner argued that the fact that the agents for the state were willing to manufacture evidence taints the veracity of the testimony from Cole and Asaro. The motions court denied this claim without an evidentiary hearing. The state Supreme Court held that it was speculative and conclusory to allege that the prosecutor's offer of assistance to 2 men who did not testify at trial is tantamount to the manufacture of evidence that negatively impacts the credibility of witnesses who testified and were subject to cross-examination. So basically, even though we know Asaro and Cole were both offered and sought benefits, they were incentivized. The motions court ruled that it was not tantamount to know that the state tried to manufacture evidence against Williams by offering 2 other men assistance with their ongoing criminal prosecutions. So we know that Cole was assisted with his parole. He wanted to work out a deal in exchange for testimony. We know that Asaro, when police first approached her, was thinking that they were about to arrest her on outstanding warrants she had for solicitation. She was offered protection there. But we're hearing that the motions court thinks that it's not relevant, it's not tantamount, that this could have negatively impacted the credibility of the witnesses that did testify. Sure. Petitioner next claimed ineffective assistance of counsel because trial counsel failed to investigate several members of Cole's family who would have testified that Cole was dishonest, involved in prior misconduct, and failed to obtain expert testimony that Cole was mentally ill and dishonest. The state Supreme Court agreed with the motions court that prior unrelated misconduct was not admissible to impeach Cole, and that trial counsel was not ineffective for failing to investigate and introduce inadmissible evidence. Petitioner also claimed that trial counsel was ineffective for failing to interview 2 potential witnesses about Asaro's criminal and medical history. The motions court found that this testimony would have been cumulative to the evidence at trial because the record contained evidence about Asaro's drug addiction, prostitution, and that she might receive reward money for testifying at trial. Petitioner also claimed that trial counsel was ineffective for failing to investigate Asaro's mother and several of his family members. Maybe his own, or do they mean of Asaro's family members? Anyway, petitioner alleged that Asaro's mother would have testified that the car was inoperable in August 1998. Asaro's mother would have testified that she saw Asaro and petitioner use public transit on several occasions in August 1998. The motions court concluded that testimony would not have established that the car was inoperable on the date of the murder and would have been cumulative because petitioner's brother testified at trial that the car was inoperable. See, I disagree there because if the jury didn't find that the brother was credible because maybe he just wanted to defend his brother, hearing the same testimony from Asaro's mother, that's a different witness with a different, they can weigh her credibility differently. Also, her testimony about the operability of the car and what she was told by Asaro admissible or not, maybe it would be hearsay, could involve different details. So, I mean, that seems like a stretch of discretion there, but whatever. Marcellus also claimed that trial counsel was ineffective for failing to test Assaro's blood, hair, and fibers in order to connect Assaro to the crime scene, failing to request a limiting instruction for evidence about an attempted escape and an assault and for evidence of other crimes, and failing to introduce mitigation evidence during the penalty phase, failing to file a motion to quash the indictment, and not allowing him to testify during the penalty phase. The motions court didn't agree with any of this. They did hold an evidentiary hearing on the claim that defense counsel failed to advise petitioner that he could testify during the penalty phase. Both defense trial attorneys testified and petitioner testified by deposition. The motions court credited the attorneys, noting that the attorneys were experienced in capital cases and that their standard practice was to advise capital clients of their right to testify. So, motions court denies the claim. Petitioner next claimed that appellate counsel was ineffective for failing to raise on direct appeal that the trial court erred in denying a continuance for the defense for additional time to prepare. The motions court denied this, noting that the prosecution did not introduce at trial any evidence regarding the inmate's statement, and that defense counsel did not explain how forensic testing could establish the petitioner was not present at the crime scene. The motions court also noted that trial counsel presented testimony from 2 forensic experts that none of the petitioner's hairs were found at the crime scene and none of his DNA was found under the victim's fingernails. In other words, they're saying you were able to present some stuff that substantiates what you're complaining you weren't able to, your counsel didn't make an argument for. He also claimed that appellate counsel was ineffective for failing to raise a claim on direct appeal that the trial court erred in not allowing the defense to present expert testimony during the penalty phase about the psychological effect on his children of execution. The state Supreme Court found that the motions court did not err in denying this claim without an evidentiary hearing, noting that, to date, every court except one has concluded that testimony regarding the impact of execution on family or friends is inadmissible. The state Supreme Court also held that the motions court did not abuse its discretion in denying motions to compel production of Assaro's and Cole's corrections and mental health records, and police reports about another murder investigation in Pagedale, Missouri. The state Supreme Court noted that the state had opened its files to defense counsel and allowed defense counsel to inspect and copy the files. The state Supreme Court also noted that many of the records requested are records of private drug treatment facilities and healthcare institutions not in the possession of the prosecution, and that probation and parole records are confidential under state law. The state Supreme Court also noted that there was no showing that the Pagedale murder was connected to the Gale murder. Now, we'll find out that an investigator actually was questioning, I think we've mentioned it already in this video, but an investigator was wondering if the nature of Gale's murder was consistent with a serial killer. The motions court also denied the claim that the state's lethal injection protocol for execution is unconstitutional, the claim that trial counsel had a conflict of interest, and the motions to reject post-conviction counsel. And then we see here described that, in part, in support of the habeas petition filed by Marcellus Williams, petitioner filed a motion for discovery to compel the state to direct the St. Louis County Prosecutor's Office and the St. Louis County Crime Laboratory to discharge its duties and test the unmatched genetic materials, including hairs and fingernail scrapings, to attempt to match the samples recovered from the crime scene to Laura Assaro and to known individuals in the Missouri Felony Offender Database and the FBI profiling system. So that's SCOTUS. So basically, because there's this known evidence, there's this body evidence, and then there's also a known male's DNA on the murder weapon that does not belong to Marcellus Williams. So basically, this motion was like, hey, look for other suspects. See if there's a match. Because you can't there's no physical evidence, there's no forensic evidence putting me, Marcellus Williams, at the scene. Run the samples through the state and the FBI's nationwide database. See if you can find a match. Because as noted above, biological trace evidence recovered from the crime scene was not matched to petitioner, the victim, or the victim's husband. Petitioner argues that there is a significant likelihood that further testing could match this trace evidence to an individual in state DNA or federal DNA databases, and thus establish that petitioner is actually innocent of the crime. Petitioner claimed in the state post-conviction proceeding that trial counsel was ineffective for failing to test the traced evidence and match it to Assaro. Petitioner also filed motion for discovery to obtain relevant impeachment material relating to Henry Cole and Laura Assaro, exonerating evidence regarding the 1998 murder of Deborah McLean, and any similar stabbing homicides occurring in the St. Louis metropolitan area from 1996 to the present, and evidence of governmental misconduct pertaining to the search of petitioner's car parked at the home of petitioner's grandfather. And then they summarize all of these things that, if they were actually fully developed through discovery and evidentiary hearings, would establish that Marcellus Williams is actually innocent of the crime. The motions to conduct further DNA testing, to authorize discovery, and to hold an evidentiary hearing were denied. So now let's look at what Kent Gibson and Lawrence Kopp put together to prepare for the Supreme Court of the United States. So SCOTUS, this top level that we're talking about here. They submitted this on August 18th. They submitted a petition for a stay of execution, an emergency, because the clock was ticking at that point in 2017. And with that petition for an emergency stay of execution, they also submitted this petition for a writ of certiorari. And in this is obviously written in a way that's favorable to the defense. It's being prepared by the defense's counsel here. And because it's being written for the Supreme Court, there's a lot of arguments being made on precedent, what this means for other innocent people that have been convicted of crimes. It really focuses on constitutional arguments, heavily relying on the 8th and 14th Amendments. 8th is dealing with cruel and unusual punishment. 14th is dealing with due process. And even though several cases will be mentioned for, precedent and case law, they really go after the Supreme Court's prior ruling in a 2003 case, Herrera v. Collins, which involved whether due process and the cruel and unusual punishment clauses of the 8th and the 14th Amendments prohibit the incarceration and execution of an innocent prisoner. The Herrera decision has created a great deal of confusion between, various states and federal courts over whether or not innocent prisoners have a due process right to post-conviction relief where credible and substantial freestanding claims of innocence are advanced. Now, this question becomes even more important. Herrera was 2003. We are entering 2024 in just a couple days. And the technological landscape has evolved. We see that at play in this case here for Marcellus Williams with the touch DNA evidence coming about in 2016 that fully excludes him from the murder weapon. So this is a long read. It is 46 pages. If you want to read the thing in full, I was really impressed by it since we are entering a period of uncertainty about Marcellus Williams' future and whether or not he will be executed by the state of Missouri. Now that the new governor, Governor Paron, has kind of said, hey, there's no legal obstacle anymore to prevent his execution. The arguments that we're seeing made here in this document from 2017 can be very relevant today. So, questions presented is what they're asking the Supreme Court to look at and consider answering and addressing. Petitioner Marcellus Williams, a Missouri death row inmate who has maintained his innocence since he was charged with murder and sentenced to death in the stabbing death of Felicia Gale during a home invasion, obtained new DNA testing in 2015 based on advances in DNA technology. An unknown male DNA profile was found on the handle of the knife that did not match the known DNA of petitioner. Based upon the uncontradicted opinions of 2 DNA experts that petitioner could be excluded as the source of the male DNA detected on the knife, petitioner filed an original petition for a writ of habeas corpus before the Missouri Supreme Court on August 14, 2017, that raised a freestanding claim of innocence based on these new DNA test results and other existing evidence that had previously emerged during prior post-conviction proceedings that undermined the credibility of the prosecution's case. In the petition, petitioner also requested an evidentiary hearing before a special master, as authorized by Missouri law, so that a trier of fact could hear and weigh all the evidence that establishes his innocence of the murder for which he was condemned to die. The following day, the Missouri Supreme Court summarily denied the habeas petition without granting a hearing in a 1-page order. In light of the foregoing facts, this petition presents the following questions. 1. Whether a freestanding claim of actual innocence presents a cognizable constitutional claim under the 8th and 14th Amendments. 2. Whether the 8th and 14th Amendments prohibit an execution from being carried out where new DNA evidence and other reliable evidence establishes that the condemned man is probably innocent. 3. Whether the Missouri Supreme Court violated petitioner's 14th Amendment rights in failing to grant him an evidentiary hearing on his claim of innocence, and in failing to re-examine the proportionality of his death sentence based upon this newly discoverable evidence as required by state law. Constitutional provisions involved. This case involves provisions of the 8th and 14th Amendments to the United States Constitution. The 8th Amendment provides, quote, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." The 14th Amendment to the United States Constitution provides in part, quote, "No state shall make or enforce any law which will abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law." And then procedural history here, they cover, he was convicted, these appeals were, the judgments were affirmed, the sentence was affirmed, post-conviction relief was denied. Judge Sipple did grant petitioner habeas relief on his one claim of ineffective assistance of counsel in the penalty phase. Respondent filed a timely notice of appeal, and petitioner thereafter filed a timely cross-appeal and moved for a certificate of appealability, but the district court denied that. Denied. After briefing and argument, the 8th Circuit Court of Appeals, by a 2-1 vote, reversed the district court, and a lot of this is saying, like, hey, we went through all these courts, we need you, SCOTUS. And we need you because there's an issue of constitutional rights at play here. And now this detail I think is important because we get to that Missouri Supreme Court's one-page denial. So on May 26, 2015, the Missouri Supreme Court appointed Boone County, Missouri Circuit Judge Gary Oxenhandler as a special master to oversee further DNA testing in conjunction with the underlying habeas petition. However, the court did not authorize the master to conduct an evidentiary hearing after DNA tests were completed or consider the McLean murder evidence. After DNA testing was complete, and remember, the McLean murder evidence could be, possible tie to an identifiable subject. That could have been the person that actually committed the Gale murder. After DNA testing was completed by Bode Laboratory, the parties filed post-testing briefs accompanied by the deposition of a Bode Laboratory technician and the affidavit of DNA expert Nora Rudin. On January 31st, 2017, the Missouri Supreme Court summarily denied the habeas corpus petition without explanation in a one-page order. The Missouri Supreme Court thereafter set an August 22nd, 2017 execution date for the petitioner. So remember, they're sending this is like a few days before this execution date. They're telling the Supreme Court, hey, this is how we got here. Petitioner thereafter filed a timely petition for a writ of certiorari to this court. The court denied this petition on June 26, 2017. On August 14th, 2017, at approximately 12:54 p.m., they're counting the minutes here, petitioner filed an original petition for writ of habeas corpus accompanied by 18 exhibits pursuant to Missouri Supreme Court Rule 91 before the Missouri Supreme Court. On August 15th, 2017, at approximately 12:56 p.m., so they're saying 2 minutes more than 24 hours, respondent filed suggestions in opposition. Approximately 2 hours later, the Missouri Supreme Court summarily denied the petition and the motion for stay of execution. Damn, they are doing the math. That's insane. So basically, the 2 hours, maybe less than 2 hours, they're just like, oh, no, we're denying this. And then let's get to the statement of facts. Now, remember, this is coming from the defense. So what we read through a little bit earlier, those couple of pages, was coming from a memorandum from one of the district courts, but it was using a lot of information from the record on the prosecution's theory of the case. This is going to be written from the defense's perspective, and more importantly, from the perspective, it's arguments being made by Marcellus Williams' current counsel, who have been appointed and are being funded by organizations like the Innocence Project, and who are dedicating a lot of time and research into this case. Something that was a different experience if we go back to like 2005 and are looking at Marcellus's pro se filings and any filings from a public defender. And nothing against public defenders, it's just as stated in this very case, they're busy. They're working on more than one capital murder trial at a time. It's hard to use your eyes to see all of the details you need to be aware of when you're stretched thin. So this statement of facts, just to give you a who's who this is coming from, it's Kent Gibson, it's Lawrence Comp. These are the big guns writing for the big guns, the Supreme Court of the United States. So, statement of facts. Marcellus Williams was convicted in 2001 for the 1998 murder of Felicia Gale, who was stabbed to death in her University City home, on the word of 2 paid informants whose testimony was inherently unreliable. Despite the violent and bloody nature of the crime scene, police failed to uncover any forensic evidence connecting petitioner to the murder. So, There's forensic evidence everywhere. There's physical evidence everywhere, and police fail to uncover anything that connects the petitioner to the murder. All this physical and forensic evidence. The wording of this is important. Like, each word kind of counts. In fact, physical evidence collected from the crime scene, including hair and footprints, could not be linked to petitioner, the victim, or her husband, suggesting that the actual killer may still be at large. Because the murder went unsolved for nearly a year, the authorities resorted to the snitch testimony of Henry Cole and Laura Asaro to make an arrest. Because the victim was a former reporter with the St. Louis Post-Dispatch and the wife of a prominent St. Louis area physician, the case generated enormous publicity. After the murder went unsolved for several months, Henry Cole and Laura Asaro came forward in June of 1999 and claimed that petitioner had confessed to committing the murder in order to lay claim to a $10,000 reward that was offered for information about the homicide by the victim's husband. Now, this was interesting because in the stuff that we've read previously, it seemed like Henry Cole and Laura Asaro came into play at different times for different reasons, but here, in this, we're seeing that, hey, they both pop up in June 1999, saying that he said he did it, he told me, because of a $10,000 cash reward, after months of no leads on the high-profile case. Henry Cole is a career criminal with convictions dating back 30 years. Mr. Cole has a long history of mental illness, evidence that the jury did not hear. The state's other star witness, Laura Asaro, also has a checkered background. She is an admitted crack addict and prostitute who was supposed... See, we didn't hear it. We heard solicitation, but I don't think we heard the word prostitute anywhere else. They're saying it here. And they're not saying it. They're saying she admitted to it. She's an admitted crack addict and prostitute who was supposedly petitioner's girlfriend for 2 weeks earlier, for a 2-month period around the time of Gail's murder. Like, think of the wording here. Henry Cole is a career criminal. The state's other star witness, Laura Asaro, is an admitted crack addict and prostitute who was also apparently the petitioner's girlfriend for a 2-month period. So she's a prostitute, but she was also in a committed relationship of some sort. And both of these people turn up right as $10,000 is announced. Both of these witnesses testified at trial that the petitioner admitted to them that he had murdered Miss Gail. Mr. Williams' alleged jailhouse confession to Mr. Cole gave a much different account of the crime than his alleged confession to the prostitute girlfriend. See, they are emphasizing that, his prostitute girlfriend. As a result, it is abundantly clear that at least one of these witnesses, if not both of them, committed perjury at trial in exchange for the reward money. Although trial counsel tried to... That's his original defense, Marcellus' original defense when they say trial counsel. Although trial counsel tried to expose Cole's and Asaro's credibility problems before the jury, they were denied access to impeaching information and failed to uncover Cole's and Asaro's histories of mental illness before trial. Trial counsel Joseph Green and Christopher McGrath were hired by the Missouri Public Defender System to represent petitioner at his trial. Both Green and McGrath were admittedly unprepared for trial. In fact, Green sought a continuance because he was involved in another highly publicized St. Louis County capital murder trial involving Kenneth Bumrock, which started just a month before Mr. Williams' trial commenced. In denying virtually all of defense counsel's discovery requests for forensic testing, and 2 requests for a continuance based on the state's failure to produce impeaching information on Cole and Asaro, the trial court pushed the case to trial beginning June 4th, 2001. In a racially charged case, Miss Gail was white and petitioner is black. The prosecutor struck 6 of the 7 black jurors, leaving just 1 black juror to serve on the jury. Due to trial counsel's lack of preparation, coupled with several trial court rulings, the jury did not receive a complete picture of the case during the guilt phase of the trial. Because the prosecution failed to disclose impeaching information, and because trial counsel did not conduct a reasonable investigation, trial counsel's cross-examination of Cole and Asaro barely scratched the surface of establishing their utter lack of credibility. As will be discussed in greater detail below, new information came to light during state post-conviction proceedings, including information regarding both of these witnesses' long history of drug abuse and mental illness, which would have further undermined their credibility in the eyes of the jury. Because the jury did not hear this evidence, it was no surprise when the jury found petitioner guilty as charged. So we're coming off of reading something else where they're like, no, they heard enough, they heard what they needed to hear, there's nothing that would have changed, this wasn't prejudicial to the defense, blah, 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 blah. And now we're like, no, the jury did not hear this evidence of their utter lack of credibility, and that's why he was found guilty. And then we dive into more details on how the events unfolded. On August 11th, 1998, Felicia Gale was stabbed to death in her home in University City, Missouri. Months went by without any charges being filed. On November 29th, 1999, that's over a year later, The state charged Petitioner with first-degree murder and armed criminal action after Cole and Asaro came forward. Subsequently, on January 6, 2000, Petitioner was indicted on these offenses and the additional charges of burglary in the first degree, robbery in the first degree, and an additional count of armed criminal action. The autopsy revealed that Miss Gale died from a total of 16 stab wounds to her head, neck, chest, and abdomen, 7 of which could have been fatal. There were 43 stab wounds on her entire body. A kitchen knife was left in her body. The police collected blood and skin samples from under Gale's fingernails. Frustrated by the lack of progress in solving the crime, Miss Gale's husband, Dr. Daniel Pikus, offered a $10,000 reward for information. The police still had no leads on the case until June 4, 1999, when 12-time convicted criminal Henry Cole came forward. Between April and June of 1999, Cole testified that he was in the city jail with Petitioner. After a few weeks, he and Petitioner realized they were distantly related and, according to Cole, became friends. Cole stated that in early or mid-May, he was watching television with Petitioner when a story came on about Felicia Gale's death, reporting that there was still no suspects and that a reward for $10,000 had been offered. According to Cole, who had known Petitioner only for a few weeks, Petitioner admitted to him that he had committed the crime. So they're sitting there watching TV in the city jail, and he just turns and goes like, "Bro, I killed that lady." That's what Cole is saying happened. Cole also claimed Petitioner had indicated to him that the only other witness he had told about the crime was Laura Asaro. In November 1999, officers went to Miss Asaro's mother's house to speak with her. Miss Asaro believed that the officers were there to arrest her on outstanding warrants. The police offered to help Asaro with her warrants if she would provide information about the murder. Asaro agreed to cooperate, becoming the second material witness against Petitioner. So, this is the star witness. Asaro testified that at the time of the crime, she had been dating Petitioner for 2 or 3 months, living at times in his car. Asaro claimed that on the day of the murder, Petitioner drove her to her mother's house around 9 a.m. and returned the car later that afternoon at about 3 p.m. Asaro claimed Petitioner was wearing a jacket zipped to the top, despite the August heat and the car having no operable air conditioner. After removing the jacket, Asaro claimed she saw blood on his shirt and fingernail scratches on his neck. Petitioner allegedly explained he had been in a fight. But it's interesting they put 1855, which is several pages apart, so it seems like they circled back to this question because something seemed questionable about it. Petitioner allegedly explained he had been in a fight. Later that day, Asaro claimed that Petitioner took off his clothing, placed it in his backpack, and threw it down a sewer. I mean, I guess if you mush, if it's cloth and you mush, depending on how big the jacket was, he was a grown man, I guess you could mush it down a typical street drain. Asaro also testified that when Petitioner picked her up, he had a computer in the car. She stated that he took it to a house down the street and, upon returning, the computer was gone. The next morning, when she wanted to retrieve her clothes from the trunk of Petitioner's car, Asaro says she gained access to the trunk and saw a woman's purse. Now I want to pause there because he drops her off at 9 a.m., comes and picks her up around 3 p.m. She says, oh, he was clearly in a fight and there was a laptop all of a sudden and he wanted to go whatever, and then the computer was just gone. And it looks like they question her twice about this statement here, separate pages. And that's interesting to me because Williams is wanting her DNA to be tested because Felicia Gale's belongings are in this car that Asaro is also living out of. And the hearsay testimony from the person who bought the laptop, he stated in deposition, and they wanted to bring it in at trial, that, he was told it was Asaro's laptop. So you get picked up at 3 p.m. and he goes with you. He didn't do this on his errands. He came and picked you up. He was doing whatever all day, but came and picked you up with bloody clothes. So instead of picking you up at 3:15 or 3:30 after disposing of his bloody clothes, he picks you up and then immediately decides, oh, I've been in a fight. That's why I have scratches. And this doesn't make sense to me. Because he could have just gone and sold this laptop. If he had just stolen it, he could have gone and sold this laptop before picking her up. But it's just weird to me that, she leaves those details out. The computer's just gone now. And it's he picks her up. He has a computer in the car. He takes it down the street. Does he drive the car with them both in it down the street? This is so unclear. And they're using the transcripts here to pull what she said. I don't know. To me, I wish I could hear this. This is obviously just what I'm reading, but to me, when someone would say hey, he picked me up, we were in the car together, Oh, I don't know. He went down the street and then the computer was gone. But you leave out details like we both drove together, or he parked the car on the side of the street, got out of the car, and then walked somewhere else. I saw him walk down the street. It's possible that this is on this one page of transcript here, but it's questionable to me that some of these details are left out. He didn't say anything to you, what he did with the computer. You're unaware of whether or not you drove with him to this house down the street. Because did you get out of the car and then he left you standing somewhere and then he drove down, and then when you got back in the car, the laptop wasn't in the car anymore and you guys didn't even talk about it? Because it's very interesting. We have the person who bought the laptop saying, hey, he said Asara wanted to sell it, that it was hers, and he was selling it for her. So to me, he could have picked this girl up at 3 p.m. because she wanted to go sell something to make money for drugs, and then she comes around and says, hey, this is a $10,000 reward. And if I just say, like, yeah, this laptop that I know belonged to Gail Felicia, I could just pin it on him and say he was the one that stole it. And that, I don't know what was happening. He had bloody clothes, he was scratched up, and then the computer just disappeared. I don't know what happened. It just doesn't make sense to me that when your car is already unreliable, you would go out of your way to go pick someone else up if you already had the laptop in your car and already had the plan to sell it. It seems to me like you were planning to meet up with Asaro and she had this laptop that she wanted to sell. I think one makes more sense than the other. Not definitively, of course, but I can definitely see why there's a credibility issue here. The next morning, when she wanted to retrieve her clothes from the trunk of Petitioner's car, Asaro says she gained access to the trunk and saw a woman's purse. Snatching the purse away from Petitioner, Asaro claimed she opened it and saw the victim's identification and coin bag. Well, so hold on. Asaro gained access to the trunk and sees a woman's purse, and then suddenly she's snatching it away from the Petitioner. So what happened for him to be... Did you both open the trunk together? What do you mean you gained access to the trunk? Like, if you're living in there, you probably know how to open it. You don't need keys to open a trunk. So you gained access to the trunk, and then you have to snatch it away from the Petitioner. You don't describe why the Petitioner grabbed it, how he was walking around with it. These details don't seem to reconcile to me. Asaro claimed she opened it and saw the victim's identification and coin bag. She became angry, believing that the Petitioner had another girlfriend. Asaro claimed that the Petitioner's response was to tell her that the purse belonged to a woman he just killed. So he's like, oh no, baby, I'm not cheating on you, I'm just murdering people. If you're scared of getting caught cheating, your excuse to get out of cheating is that you killed somebody? Like, this is just so... This is their star witness in this case. In contrast to Cole's account, and in direct conflict with the crime scene evidence, Asaro claimed Petitioner told her that he broke into the woman's house through the back door, and they questioned on her twice. This is 2 separate transcript pages. Asaro then gave a general account of a surprise encounter with the victim, a struggle, and an account of the stabbing. Now, that's interesting because we read elsewhere that he laid and waited. He, waited for the woman to come out of the shower. If someone was in the shower, why wouldn't you just grab and go? You just grabbed a purse and a laptop? Those sound like things that could be sitting on a counter. You don't even need to wait for someone to get out of the shower. Unlike Cole, Asaro testified that the Petitioner drove down to the scene and did not take a bus. Like Cole, Asaro admitted that she was also interested in the reward money. Now, this is actually huge, because if Asaro is lying, and Asaro has awareness of where this robbed stuff came from, it was something that, was robbed because drug money or whatever, she would have to come up with an explanation of why that stuff was in the car. Well, yeah, he was gone all day, he dropped me off, he was gone from 9 to 3. How would you even know that the Petitioner drove to the scene? You're just saying that this is what he told you? So either Williams is telling Cole and Asaro, on one hand, yeah, I killed her and I took a bus to get there, or yeah, I killed her and I drove the car to do it. With Asaro, we know she's stating that she didn't see him from 9 to 3, that he left the car and returned with the car, and that there was a laptop in the car when he picked her up at 3 p.m. So it seems to me like Asaro needed to figure out a way to put that laptop in the car. It's possible, I guess, he could have had it with him on the bus, and when he got to the car at the bus stop, obviously everything he had with him, if he just robbed this lady, he put in the car. But I have a lot of questions if Cole and Asaro's story are different, and they weren't there for this to happen. They're basing it off of what Marcellus Williams told them. Why would he change that detail from one person to another if he's admitting to what he did? If he's not lying and trying to say he didn't murder somebody, if he's telling the truth and making statements to Cole and to Asaro, hey, I'm confessing to you that I killed this lady and here's how I did it. Why would he lie about the bus and the car detail from one person to the next? Anyway, like Cole, Asaro admitted that she was also interested in the reward money because the state's case hinged on two highly unbelievable witnesses. And that's how I feel. I don't even feel like, there's credibility, there's inconsistencies. I feel like they're unbelievable. I feel like there's a lie here. I feel like Cole worked backwards to put information together and might not be making everything up. I think he's working with details that he could get his hands on or become aware of. Maybe he even knows Asaro, who knows? He's a career criminal. She's a known prostitute and drug addict. I don't actually know his rap sheet, but, they could have crossed paths. But if Cole is working with details that he's finding from other people or in newspapers or being told by somebody or being asked by the prosecution and he's just like working a story around it, then where would Asaro get this detail? And like, no, he drove to the scene with his own car. I agree. It's highly unbelievable. It's not just I don't know, I don't recall, or I'm unsure. This is well, how are you certain he drove to the scene and didn't take the bus? Defense counsel focused on the lack of forensic evidence linking Petitioner to this extremely bloody murder scene, and suggested that police could have easily fed information to Cole and Asaro to resolve this long unsolved, high-profile crime. For example, numerous hairs were discovered on the victim's shirt and on the rug where her body was found. The rug had been vacuumed 11 days before the crime. While some of the hairs matched Gale or Picus, others did not match either of them or Petitioner. Similarly, 2 pubic hairs found on the rug did not match Gale, Picus, or Petitioner. Head hairs also found on the rug did not match any of these 3 individuals. None of these unmatched hairs, nor the knife, were ever tested for DNA by either the prosecution or the defense. In addition, fingernail clippings taken from Gale that contained blood and skin cannot be matched to Petitioner. Bloody footprints at the scene appeared to belong to a single assailant. None of the bloody shoe prints matched any paramedic shoes, nor did they match the shoes seized from Petitioner upon his arrest. Throughout the state and federal post-conviction process, Petitioner was never afforded a hearing on any of his constitutional claims involving the credibility of Mr. Cole or Ms. Asaro. Petitioner was denied a hearing on the DNA testing issue during his 2915 litigation. Furthermore, the federal district court denied all of Petitioner's discovery requests regarding the similar murder of Deborah McLean and all other attempts to obtain further DNA testing of the untested and unmatched materials in this case. So again, that argument of there could be another suspect out there. You have positive evidence that somebody else was in that property. You have the hairs. You have the footprints. You have the knife. Why don't you try to run any of those samples through a database? Why don't you look at the similar murder pattern of Deborah McLean? It's like, no, we have these 2 witnesses that wanted a $10,000 reward saying it was you, so we're certain it was you. In his federal habeas petition, Petitioner advanced a freestanding claim of actual innocence, coupled with the claim that he was convicted on the basis of the perjured testimony of Cole and Asaro. In the litigation of his federal habeas petition before the district court, Petitioner filed numerous motions and requests for discovery seeking access to impeaching information regarding Cole and Asaro, the police investigation of the McLean murder, and for further DNA testing of untested items and genetic materials. As noted earlier, there was trace evidence collected at the scene that did not microscopically match Petitioner, the victim, or her husband. In particular, there were both head and pubic hairs found at the crime scene that did not match the victim, her husband, or Petitioner. Fingernail clippings taken from the victim revealed testable blood and skin samples. Although these samples contained some of the victim's DNA, there was no DNA match to Petitioner. In light of Ms. Asaro's account of the crime, indicating that the Petitioner had scratches on his body, and, he also said that he was in a fight, according to her, if her account was true, Mr. Williams' DNA should have been found in the victim's fingernail scrapings. Petitioner also sought access through discovery motions filed in his 2254 action to police reports, lab reports, and any DNA profiles developed in the unsolved murder of Deborah McLean, which occurred in Pagedale, Missouri, on July 18, 1998. Apart from the temporal and geographical proximity of these murders, there were other remarkable similarities between the 2 cases. St. Louis County Medical Examiner Dr. Mary Case thought that these murders were connected. At a meeting with the chief detectives investigating the Gale homicide, Dr. Case articulated the following similarities between the murders of Miss Gale and Miss McLean. The age of the victims, McLean was 40, Gale was 42. Both women were of similar build and had long brown hair. I don't know, it's black and white. It kind of looks light to me, but who knows. I guess it looks dark on one side, but blonde where the light is shining. The injuries were similar in that both were stabbed on the right side of the neck and had numerous stab wounds in the front and back upper trunk area. Crime scenes were very similar in that very little was disturbed. Each victim was stabbed with a knife from her own kitchen drawer, and the victim's purse were missing in both cases, and both victims had defensive wounds. Most importantly, Dr. Case noted the unusual factor that the victim in each case still had the knife in her body, which according to Dr. Case is extremely rare. In fact, one investigator thought the killings were the work of a serial killer. The murder of Deborah McLean remained unsolved at the time of Petitioner's 2001 trial and apparently remains unsolved to this day. This is still written in 2017. That might be true today in 2023. I'm not sure. As a result, any and all of police records, crime laboratory testing, and other reports generated in the case are closed records under Missouri's Sunshine Law. In light of advances in DNA technology and the creation of both the state and the SCOTUS databases, Petitioner also unsuccessfully sought access to any available items of evidence in the McLean case, such as the knife and any trace evidence for DNA testing, and, if any profiles have been or are developed, to have such profiles run through these databases. As noted earlier, the Missouri Supreme Court in 2015 stayed Petitioner's execution and appointed Judge Oxenhandler as a special master to oversee DNA testing of trace evidence from the crime scene of the Gale murder. However, the Missouri Supreme Court did not authorize the master to conduct any hearings on Petitioner's broader claim of actual innocence, nor did the Supreme Court order that Judge Oxenhandler address Petitioner's request for evidence regarding the McLean murder. As a result, the proceedings before the master merely involved the parties making arrangements to have the trace evidence from the scene of the Gale murder tested by Bode Laboratory. After the Bode Laboratories completed testing, they issued a report finding that despite the fact that several alleles at 11 different loci from the YSTR DNA testing of the knife did not match the known DNA of Petitioner, that the threshold levels were too low to make a conclusive exclusion. After the testing was completed, the parties took the deposition of a Bode Laboratory technician and submitted post-DNA testing briefs. Before Petitioner's post-DNA testing brief was filed, he secured the assistance of DNA expert Nora Rudin, Ph.D. After reviewing all the DNA reports from the Bode Laboratory, Dr. Rudin concluded that Marcellus Williams could not have contributed to the detected DNA profile found on the knife that murdered Felicia Gale. On January 1, 2017, Judge Oxenhandler submitted all of the DNA data and the briefs of the parties to the Missouri Supreme Court. Less than a month later, the Missouri Supreme Court summarily denied the habeas petition without any further briefing or argument in a one-line order. So a one-line order here, a one-page order earlier, 18 exhibits, new DNA evidence, touch DNA, new methods, completely exclude Marcellus Williams. That's why when I opened this video, and I looked at this writing, this piece by Leonard Pitts from August 27th, 2017. That's why I think what he wrote was so compelling. It is human nature that human beings are loath to admit their mistakes. It is also human nature that human beings will make mistakes regardless. One of the most grievous flaws of capital punishment is that it requires us to pretend those two things are not true. That is why the court's refusal to stop Williams' execution is less suggestive of reasoned jurisprudence than of a refusal to look too closely for fear of what one might see. A one-line order denying a habeas petition without any further briefing or argument, in response to renowned DNA experts saying, hey, this person you convicted could not have contributed to this murder weapon. The DNA that we're examining is just not happening. It's not him. You get a one-line order, no briefing, no argument. That is this, a refusal to look too closely for fear of what one might see. We avert our eyes from all this. That is the sobering truth of the day Marcellus Williams was scheduled to die and didn't. This is 2017, and it is 2023, and we are a couple days from 2024. And still, no finder of fact, no court has addressed or heard this evidence that exonerates Marcellus Williams. CJA appointed co-counsel for Mr. Williams, Lawrence Kump, was recently hired to become the director of the newly created Missouri Capital Habeas Unit, CHU. The CHU began operations on Monday, July 24th, 2017. So, July, August, this guy got in guns blazing in 30 days. At that time, counsel for petitioner were relying upon pro bono expert assistance and limited financial assistance from the Missouri Public Defender's Office to fund the DNA testing and other expert assistance necessary for executive clemency and the 2015 Rule 91 litigation. As a result, no additional funding was available for any other expert assistance on the DNA issues in this case until the Missouri CHU began its operation less than a month ago. As a result of the creation of the CHU, federal funding was recently secured for the expert assistance of DNA expert Dr. Greg Hempikian, a DNA expert and professor at Boise State University. In 2015, Dr. Hampikian had generously agreed to provide pro bono assistance in petitioner's clemency and previous Rule 91 proceedings. Dr. Hampikian was provided with all of the reports and data from the Bode Laboratory and has thoroughly analyzed all of these materials. Dr. Hampikian, in a report that he completed on Sunday, August 13, 2017, now removes any doubt that the YSTR testing of the knife and the male DNA profile developed therefrom conclusively excludes petitioner as the perpetrator of this murder. Dr. Hampikian's report comprehensively describes the common laboratory techniques that scientists employ in conducting YSTR DNA testing to attempt to develop a male DNA profile and explains, in layman's terms, why it is clear that Marcellus Williams did not contribute the male DNA that was found on the knife recovered from the victim's body. Although it is difficult for YSTR DNA testing to conclusively identify an individual, Dr. Hampikian explained that even incomplete YSTR profiles can be utilized, that's a typo, to definitively exclude a contributor. In explaining this method of exclusion, Dr. H used an analogy involving a partial Social Security card number. Dr. H explained that if only 4 numbers are visible on the hypothetical card, anyone whose Social Security number does not include those digits can be eliminated as a match. Because several of the called alleles in both knife handle swabs conducted by the laboratory do not match the alleles of Marcellus Williams, there is a clear exclusion of Marcellus Williams from both knife handle samples. Petitioner also intended to submit to the Missouri Supreme Court in a reply a declaration of Dr. Randall Libby that was submitted in a DNA case litigated in the state of Idaho involving former death row inmate George Jr. Porter. Dr. Libby's affidavit demonstrated that Dr. Hampikian's findings were correct and, notwithstanding Bode Laboratory's protocol, that almost every crime lab in the country, including the FBI, can exclude an individual as a contributor from a biological sample if the RFU falls between 50 and 200. Since Dr. H found that 3 alleles developed from the knife handle that did not match petitioner's known alleles at the same loci, with an RFU in this range, petitioner could definitively be excluded as contributor of the male DNA that was found on the knife handle. Based upon Dr. H's affidavit and all other previously discovered evidence of innocence, petitioner filed a petition for a writ of habeas corpus, accompanied by a stay of execution motion, before the Missouri Supreme Court on August 14, 2017. This petition raised a claim of innocence under federal and state law and requested an evidentiary hearing because no court had held a hearing on his claim of innocence. The Missouri Supreme Court summarily denied the petition and the stay of execution motion on August 15, 2017. The present petition for a writ of certiorari is now before this court for its consideration. And now everything that we just went through kind of goes to the idea of innocence in terms of the conviction of guilt, the judgment of guilt, the evidence used in the case, the sufficiency of the evidence, problems with the evidence, problems with what evidence was known at the time and not available to the jury, or problems with evidence that wasn't known at the time but has become known now. So based on all of that, I mean, I have questions of guilt. I have questions on the verdict. I have questions on the judgment of guilt. What about you? What are your thoughts there? Because what we're going to look at next is, this is where they're going to argue and ask the Supreme Court to address questions of 8th and 14th Amendment rights, due process, unlawful imprisonment, and if the current incarceration and the death sentence for this person who's maintaining their innocence on the grounds previously discussed. And throughout this, we're going to see it mention that the impetus for answering this question isn't just because this man's life is on the line. There's an impetus because this case is going to come up again. This will not be the last case where DNA evidence can pop up that could exonerate someone that's already been convicted and been spending years in prison. And this is not going to be the only case where there's an issue of post-conviction relief and how that process plays out in different districts. So this stuff gets a little bit more into case law and arguments at the SCOTUS level. But to me, they're really compelling beyond just what they would mean for this individual case involving Marcellus Williams. It's something that impacts all citizens and the right to due process. So feel free to express your thoughts now on, where do you stand on the conviction? Do you agree with the state of Missouri and the governor and the prosecution? You've had Josh Hawley's office previously say, oh, it stands, he's definitely guilty. You have Bob McCulloch, 100% without a doubt, there's zero chance that he's not guilty. And then on the flip side, you have the NAACP of the Innocence Project. You have random people on social media that are kind of like, no, some of this is questionable, and not just the DNA evidence not being there. You have all this physical forensic evidence that suggests it was not him. But then the only positive evidence you have saying it was him was 2 witnesses that were interested in a $10,000 reward and also got money from the prosecution and also got benefits related to their own warrants or existing parole with a suspended prison sentence. One that was almost named as a co-conspirator in a separate crime. Those are the star witnesses. That's the positive evidence that was used to convict Marcellus Williams. I have questions about all of it. And I think one question is enough to say, hey, the death penalty should not be on the table for somebody. So this is no longer a case of asking yourself, if someone's 100% guilty, do you think the death penalty is okay? It's a case of a sentencing to death that was affirmed by courts that refused to hear this other evidence, to hold new evidentiary hearings, to review this DNA evidence and reconsider their conclusions and decisions that previously affirmed the standing sentencing. And I think Gibson and Comp do a really great job in making their case here that the Supreme Court never had to hear. You know, this was 2017. It was right before the governor said, all right, I'm issuing an executive order to stay the execution. There's some compelling stuff here. So if you don't want to stick around for that reading, still let me know your thoughts. Remember, you can go, the link's in the description. If you want to sign or share the petition, go ahead and do that. Honestly, hopefully by the time you're watching this petition is successful. It was the petition that got 200,000 signatures. It was the social media reactions. It was the advocacy of different organizations that have kept him alive from 2017 to right now while I'm recording this. It was not the judicial process that kept this man alive. So let's go through the 3 reasons the Supreme Court should have heard this case. To resolve the unanswered question of whether the 8th and 14th Amendments prohibit the continued incarceration and execution of a prisoner who presents a persuasive post-conviction claim of actual innocence. The facts of this case present this court with an ideal opportunity to resolve the unanswered questions and confusion spawned by this court's decision in Herrera v. Collins in 1993, regarding whether due process and the cruel and unusual punishment clauses of the 8th and 14th Amendments prohibits the incarceration and execution of an innocent prisoner. The Herrera decision has created a great deal of confusion and conflicts between the various state and federal courts that have addressed whether innocent prisoners have a due process right to post-conviction relief where credible and substantial freestanding claims of innocence are advanced. In the aftermath of Herrera, federal circuit courts of appeals are divided on whether Herrera precludes federal habeas petitioners from obtaining habeas corpus relief based on freestanding claims of actual innocence. The question of whether the federal Constitution precludes the incarceration and execution of an innocent prisoner has also divided many of the state courts who have addressed the issue. The Illinois Supreme Court determined that this court's conflicted decision in Herrera barred a federal due process claim grounded upon actual innocence, and instead relied upon the Illinois Constitution to grant the prisoner a new trial. Several other state courts have taken a similar path to grant innocent prisoners relief under state constitutions. However, in states where neither legislation nor the state constitution has been interpreted to permit innocent prisoners to obtain post-conviction relief, innocent prisoners have no legal recourse to obtain any meaningful judicial review despite compelling evidence that they are imprisoned or even condemned to die for a crime they did not commit. In the last decade, this court has made it clear that Herrera, in which the petitioner had only made a weak showing of innocence, did not actually resolve the issue of whether the Constitution precludes the execution of an innocent prisoner. This court's decision in In re Davis also strongly suggests that freestanding claims of innocence are constitutionally viable, at least in capital cases. In that case, the court remanded a death row prisoner's original petition for a writ of habeas corpus to the district court for an evidentiary hearing on his claim of innocence. After a hearing was conducted, the district court found that, quote, executing an innocent person would violate the 8th Amendment, but that Davis did not establish his innocence. Herrera recognized that the central purpose of any system of criminal justice is to convict the guilty and free the innocent. In addition, the concept of liberty from bodily restraint has been recognized as the core of the liberty protected by the Due Process Clause from arbitrary governmental action. Because an innocent person has a liberty interest in remaining free from punishment, the execution or continued incarceration of an innocent person violates elementary fairness and runs afoul of that person's due process right. Both the Herrera decision itself and subsequent decisions clearly indicate that strong procedural and substantive due process arguments can be made that the continued incarceration and execution of an innocent prisoner would violate both procedural and substantive due process under the 14th Amendment, although the majority of the court in Herrera declined to find that substantive due process would be violated by the execution of an innocent prisoner. At least 6 members of the court did agree that a truly persuasive case of actual innocence would render a conviction unconstitutional. The Illinois Supreme Court found that the continued imprisonment of an innocent person would violate both substantive and procedural due process. The court in Washington held that procedural due process required post-conviction relief because to ignore such a claim would be fundamentally unfair. The court in Washington also held that imprisonment of the innocent would also be so conscience shocking as to trigger operation of substantive due process. The continued incarceration and execution of an innocent prisoner also violates the Eighth Amendment for several reasons. Due to the heightened reliability requirement in capital sentencing proceedings, the requirements of the cruel and unusual punishment clause of the Eighth Amendment apply to death penalty cases with special force. The Eighth Amendment's heightened reliability requirement applies with equal force regarding eligibility for the death penalty and to the attendant procedural safeguards that states must provide to prevent the imposition of unjust or unconstitutional death sentences. A sentencing process that does not comport with evolving standards of decency that mark the progress of a maturing society also violates the Eighth Amendment. In determining whether an Eighth Amendment violation occurs under the evolving standards of decency test, the best indicator of contemporary values is legislation enacted by the states. In the more than 2 decades since the Herrera decision, the vast majority of the states, either through legislation, court rule, or by the interpretation of its constitution, have created a post-conviction review system that allows wrongly convicted prisoners to obtain post-conviction relief if they can present a compelling case of actual innocence. This expansion of the rights of innocent prisoners to seek legal redress has also undoubtedly been accelerated as a result of the spate of DNA exonerations resulting from scientific advances in that technology. However, as noted earlier, for those innocent prisoners in the federal system and the handful of states such as Missouri that do not provide adequate legal remedies for innocent prisoners, this court, under Simmons and Atkins, should grant review in this case in order to recognize that the United States Constitution requires that innocent prisoners have a right to be heard and obtain new trials on freestanding claims of actual innocence under the evolving standards of decency test. Another central concern of the Eighth Amendment is its protection against disproportionate punishment. This court has identified 4 penological justifications for imposing a life without parole sentence. 1. Retribution. 2. Deterrence. 3. Incapacitation. And 4. Rehabilitation. None of these purposes are served and are, in fact, undermined when the convicted individual is actually innocent. Therefore, because punishment of an actually innocent person is inherently disproportionate to the acts committed by that person, such punishment violates the constitutional prohibition on cruel and unusual punishment. These state legislative and legal developments involving innocence jurisprudence in the aftermath of Herrera dictate that its holding should be abandoned, re-examined, and clarified. Evolving standards of decency clearly dictate that it is constitutionally impermissible to allow condemned prisoners to remain incarcerated or forfeit their lives if they have a substantial claim of innocence. This court's discretionary review is necessary to ensure that innocent prisoners, such as Petitioner, have adequate judicial process to litigate their claims. Clause 2. This writ should be granted to allow this court to address whether the Constitution forbids an execution from taking place where newly discovered evidence involving exculpatory DNA results and other evidence raises reasonable doubts regarding the condemned man's guilt. So what we just looked at was talking about punishment, incarceration, and due process for someone that has freestanding innocence. Now we're looking at the question of reasonable doubt and what degree reasonable doubt should play in addressing whether execution should be allowed or forbidden if new evidence could be exculpatory. Despite the unanswered questions regarding the scope of Herrera and its progeny, an appropriate middle ground advocated by numerous legal commentators is that the Constitution prohibits an execution from proceeding where compelling evidence emerges during post-conviction proceedings that raise reasonable doubts regarding the condemned man's guilt. In such situations, even if the evidence might not meet the legal threshold suggested in Herrera, the Constitution requires that a death sentence must be commuted if there are reasonable and substantial doubts regarding the condemned man's guilt. The facts of this case provide the court an ideal opportunity to determine this important question that is likely to recur in several upcoming cases in light of advances in DNA technology in states that do not afford prisoners an adequate process to hear claims of evidence. Various commentators have differed as to what standard of proof a condemned prisoner must meet to avoid execution on a freestanding claim of innocence. It would be contrary to the dignity of man and thus the Eighth Amendment to maintain a system that allows for the execution of innocent people. This court in Robinson v. California hypothesized an extreme example of disproportionate punishment when it noted that, quote, even 1 day in prison would be a cruel and unusual punishment for the crime of having a common cold. Allowing the execution of a person who is likely innocent or even possibly innocent is an even more extreme example. For many of the same reasons, allowing the execution of a potentially innocent person presents an extreme violation of a criminal defendant's substantive due process rights. As Justice Blackmun, and there's a typo there, as Justice Blackmun's dissenting opinion in Herrera makes it clear, maintaining a system that permits the execution of factually innocent people is a far more severe violation of substantive due process than acts that have been held unconstitutional in the past. Justice Blackmun advocated that a prisoner must show that he is probably innocent, and briefly outlined how that standard might be applied. In addition, the more stringent beyond a reasonable doubt standard for criminal cases, as opposed to the lesser standard for civil cases, rests upon the value American society places on personal liberty, reflected in the maxim that it is better to allow 10 guilty men go free than to allow one innocent man to be convicted. And I personally agree with that, but I'm not everybody, so what do you think? The maxim is it's better to let 10 guilty men go free rather than allow one innocent man to be convicted. And remember that maxim is also involving power of the state, power of the government to make that choice. So an extra layer is that I extra agree that it's better for a prosecutor to let 10 people go free than to convict one person improperly and wrongly. But let me know your thoughts on that. I mean, that's a huge, we could debate on that for hours, really. Since the societal interest in life is deserving of even more protection and respect than personal liberty, Justice Harlan's position could be advanced a step further to require that an even higher standard than beyond a reasonable doubt must be met before the state may constitutionally take a convicted murderer's life. Certiorari should be granted to address whether and to what extent a condemned man must prove his innocence before his execution should be deemed a constitutionally intolerable event requiring, at a minimum, a reviewing court to set aside an impending death sentence as unconstitutional. This court's discretionary intervention is necessary not only to save an innocent man's life, but to address this important issue that will undoubtedly recur in future cases. And then 3, certiorari should be granted to address whether the Missouri Supreme Court violated petitioner's due process and equal protection rights by failing to afford petitioner an evidentiary hearing on his claim of innocence and re-examine petitioner's death sentence under its proportionality review statute, as required by state law. And now this is kind of going into state constitution versus federal rights. The manner in which the Missouri Supreme Court summarily disposed of petitioner's habeas corpus petition without affording him an evidentiary hearing, and in failing to follow its own law that requires the court to re-examine the proportionality of death sentences where newly discovered evidence of innocence emerges, implicates several constitutional concerns under the 14th Amendment. First and foremost, because the petitioner has never been afforded a hearing in any state or federal court to allow a trier of fact to evaluate the substance and credibility of his claim of innocence, based upon the new DNA evidence and other evidence set forth above that undermines the state's case. This court should intervene to address whether due process requires that an innocent prisoner under a sentence of death be afforded an evidentiary hearing where there is a colorable claim of innocence. As Justice Stevens' concurring opinion in Davis noted, because no state or federal court has ever conducted a hearing to assess the reliability of the claim of innocence in that case, quote, the substantial risk of putting an innocent man to death clearly provides an adequate justification for holding an evidentiary hearing. Ironically, as Justice Scalia's dissent in Davis points out, Troy Davis was afforded much more due process by the state of Georgia on his claim of innocence than the Missouri Supreme Court afforded to petitioner. Mr. Davis's post-conviction claim of innocence was thoroughly analyzed by the Georgia Supreme Court in a published decision, and that court concluded that the newly discovered evidence was not sufficient to probably produce a different result at a retrial. Mr. Davis also received a stay of execution after seeking clemency before the Georgia Board of Pardons and Paroles, where he was given the opportunity to present every witness he desired to support his allegation that there was doubt regarding his guilt. In contrast, Missouri's unstructured, secret, and discretionary clemency process affords no such rights to petitioner in his ongoing application for commutation of his death sentence by the governor of the state of Missouri. And we've seen a lot of that in this video already. It's just like one sentence responses. Oh, we don't want to deal with this any further. It's time to move on. Nope. Can't take a look at anything. Even if there was a report, it'd be under seal. The Missouri Supreme Court's failure to provide petitioner an evidentiary hearing on his claim of innocence in order to provide him an adequate opportunity to prove his innocence also violated due process under Williams v. Kaiser. In Williams, this court reversed the Supreme Court of Missouri outright for the reason that the original habeas corpus proceeding conducted in the Supreme Court of Missouri failed to accord the prisoner a full and fair evidentiary hearing on his federal constitutional claim. The due process issue here is also similar to the question upon which this court granted certiorari in Case v. Nebraska. but ultimately did not decide after Nebraska enacted an adequate post-conviction procedure, which this petition here, we've already seen them argue that Missouri does not have an adequate post-conviction procedure. Additional distinct 14th Amendment violations also arise from the failure of the Missouri Supreme Court to reevaluate petitioner's death sentence as required by state law. Missouri's mandatory proportionality review statute requires the consideration of, quote, whether the death sentence is excessive or disproportionate to the penalty imposed in similar cases, considering both the crime, the strength of the evidence which is underlined, and the defendant. In the petition filed in the court below, petitioner argued that in light of the new recent exculpatory DNA testing results and other evidence of innocence that came to light after his direct appeal, that the Missouri Supreme Court should reassess the proportionality of petitioner's death sentence and reach the same result that was reached in the capital direct appeal involving former Missouri death row inmate Timothy Chaney. In this case, as in Chaney, there was no eyewitness, confession, or physical evidence establishing Marcellus Williams' guilt. The state habeas petition also argued that a reassessment of the propriety of the petitioner's death sentence was required under state ex rel. Amrine v. Roper. So, in Amrine, 6 of the 7 members of the Missouri Supreme Court indicated that Missouri's proportionality review scheme requires the court to conduct an ongoing review of the propriety of a condemned prisoner's death sentence when new evidence of innocence emerges. These opinions in Amrine found that middle ground is necessary in habeas corpus cases where a condemned man presents significant post-conviction evidence raising grave doubts about his guilt that might not meet the higher standard for reversal of the underlying conviction under Amrine, but would nevertheless be sufficient to require that a prisoner's death sentence be overturned and his sentence reduced to life without parole. So in other words, if something happens post-conviction that raises doubts about guilt, and the court doesn't find that it meets the higher standard for reversal, it should be sufficient to require that a prisoner's death sentence be overturned and that his sentence is reduced to life without parole. So death is off the table. Even where all of the evidence is legally sufficient to establish guilt and does not provide clear and convincing evidence of innocence, the death penalty should still be off the table where substantial doubts regarding guilt exist. As Judge Price's dissent in Amrine advocates, where evidence of possible innocence substantially undercuts confidence in the verdict, a death sentence should be set aside. In his habeas petition filed in the Missouri Supreme Court, petitioner argued that he had a due process and equal protection right to have a new proportionality review under Amrine, not only because of newly discovered evidence, but because the 2003 proportionality review the court conducted in his direct appeal contained 2 fundamental flaws. In addressing the strength of the evidence in its original proportionality review of petitioner's sentence on direct appeal, the Supreme Court stated, quote, Williams confessed to the murder. This passage is, at best, misleading because petitioner did not confess to the police. By any objective measure, the evidence that petitioner allegedly confessed, in quotes, to the murder to 2 paid informants, who were convicted felons, does not come anywhere close to having equal weight to a voluntary confession to the police. And that's crazy. They're like literally saying he gave a confession, and most people would read that and assume he sat there in holding and told police. And the other thing, too, is like, there are plenty of exonerations, involving false or coerced confessions when someone's being interrogated by the police. And so what they're talking about here was the Missouri Supreme Court, and there was a dissenting opinion, and Wolf, he kind of goes bananas in this. And he specifically notes that a confession to the crime to a jailhouse snitch does not constitute a persuasive admission of guilt. Go Wolf, I agree. Second, it is clear that the proportionality review that the Missouri Supreme Court conducted in 2003 did not conform with the requirements of the statute. In 2010, the Missouri Supreme Court recognized that its earlier proportionality review procedure provided less than the full proportionality review required by statute. And they put the case law for that. Coupled with the mistake of fact in its 2003 proportionality review in describing the strength of the evidence presented at petitioner's trial, petitioner argued that he had a constitutional right to have his death sentence re-examined under Amrine, Deck, and Davis. The Deck and Davis opinions are clearly retroactive. Under Missouri law, where a new decision involves the interpretation of a statute that was in place at the time of conviction, no issue of retroactivity arises. Because the proportionality statute remained unchanged between the time of petitioner's direct appeal and the 2010 opinions in Deck v. Davis, the Missouri Supreme Court's failure to give him the benefit of those decisions and re-examine his death sentence violates due process under Fiore v. White and Bunkley v. Florida. The Missouri Supreme Court's failure to conduct a new proportionality review under the framework it established in 2010 also violated petitioner's right to equal protection of the law. The Equal Protection Clause of the 14th Amendment imposes upon a state the requirement that all similarly situated persons should be treated alike. Generally, legislation or a court decision will be presumed to be valid if the disparate treatment of a class of citizens is rationally related to a legitimate state interest. However, strict scrutiny of state laws is required if a suspect class is involved or when state laws impinge on personal rights protected by the Constitution. Under either of these standards of review, the Missouri Supreme Court was constitutionally required to review petitioner's death sentence in the same manner as it did considering the proportionality of Mr. Deck and Davis's sentences. There is simply no rational basis for reviewing petitioner's death sentence in a different manner than the death sentences imposed against Mr. Deck and Mr. Davis. The Missouri Supreme Court's failure to conduct a new and fair proportionality review in accordance with state law noted above also violated petitioner's right to due process under Hicks v. Oklahoma. In Hicks, the court found that a due process violation occurred when a state court did not afford a criminal defendant procedural protections guaranteed by state law. A due process violation occurred here because the state court's failure to conduct a new proportionality review arbitrarily deprived the defendant of a state law entitlement. As pointed out in the habeas petition below, a distinct due process violation also arises from the Missouri Supreme Court's failure to conduct a proportionality review that considers all of the evidence of innocence under the principles announced by this court in two civil punitive damages cases where the court held that due process required a heightened review in any civil case where punitive damages are assessed against a defendant. In BMW v. North America v. Gore, this court held that punitive damages for a civil defendant's conduct would not be appropriate unless the conduct was sufficiently reprehensible to render punitive damages proportionate to the degree of the defendant's misconduct. Those same due process principles require a heightened review when a person's life, rather than civil damages, are at stake. Although this court has held that proportionality review is not constitutionally required in capital cases, procedural due process protections are clearly implicated and were violated by the Missouri Supreme Court's treatment of petitioner's claim of innocence. Due process requires that a condemned man's claim of innocence receive much more thorough and careful scrutiny and a hearing than what occurred, where complex scientific issues surrounding the DNA results that are difficult for laymen and judges to grasp are involved. The hasty and summary denial of this claim by the court below undermines the integrity of the criminal justice system and, if left undisturbed, will result in a constitutionally intolerable event next Tuesday evening, the execution of an innocent man. The petition for a writ of certiorari should be granted. Respectfully submitted, Kent Gibson. So there you go. This is 2.5 decades of a case that has put this man's life behind bars and on his deathbed more than once now, and it could happen again. So, if you want to sign the petition to stop the execution of Marcellus Williams, an innocent man, the link is in the description. It should be the first thing at the top of the description. You can also share it, raise awareness. It helps. And sometimes this isn't just about one person, as we saw Gibson and Comp insist throughout, what they wrote in 2017 as part of their petition, their writ for the Supreme Court for SCOTUS. This isn't going to be the first and only time we have to answer these questions on what happens when someone is behind bars and they're innocent, when someone is facing the death sentence and they're innocent. What happens when someone, post-conviction, new evidence could exonerate them and the state doesn't have a process for post-conviction relief? And where do we work evolving technology into all of this? Because this isn't going to be the first time. It clearly isn't the first time. There's other cases where people have been completely exonerated because of new DNA evidence. So there's outstanding questions here, not just for the facts of this specific case involving Marcellus Williams, but the broader implications on what this means. And I have so many questions reading this. I mean, we have the Postman Gambit, this St. Louis trick of, so if we just strike postal workers, there's a good chance we can get a bunch of African Americans off the jury pool without the strikes looking like they're made on a racial basis. And the fact that that's even titled and the person who coined that tactic went on to become a judge is really concerning to me. The fact that there was a board created and an execution stayed while the board could have the time to investigate the new DNA evidence and other evidence that came to light post-conviction, but that governor resigned and then the new governor just kind of did nothing. The board was canceled for 5 years and then he made an executive order saying, hey, I'm going to make an executive order officially removing any legal obstacles to executing Marcellus Williams. It's time to move on. But we have no results. We have no report. We have no decision based on a report. Nobody has reviewed this new touch DNA evidence. Not a trier of fact. And even though the Supreme Court was asked to hear it, the emergency stay, it was no longer necessary because that governor stepped in. And then what he did to intercede, what he did to step in, was not able to play out. I've got so many questions here about Bob McCulloch, Josh Hawley's office when he was still whatever position he had before he was senator or whatever. They were so confident that this conviction was 100% correct. And I'm looking at it and I'm like, you've got two people that there were no leads for months and months, more than a year. And then there's a $10,000 reward issued. And then we hear the prosecutor put up an additional $5,000, 5 bands, promised help with these solicitation or prostitution charges for Asaro, and ignored 6 parole violations in a short period of time. Leaving out that testimony from the person who bought the laptop saying that, he was told that it was Asaro's laptop, that Asaro wanted to sell it. Asaro tripped up, I think, on, oh yeah, he drove the car and when he came back there was a laptop there. And suddenly the laptop was just gone. He went to a street. Who knows what I was doing in that time period. He picked me up and then either drove or walked himself and the laptop just poofed and disappeared. It seems like there's a lot of gaps in Asaro's story, and I think it's really crucial. I think it's really crucial that the jury didn't get to hear that the person who bought the laptop heard that it was Asaro's laptop and she wanted to sell it for money. But, the jury could have made up their mind before any of the evidence was presented anyway. I have a lot of thoughts. I have a scratch pad. It's 20 pages long with the different resources and links that I've gone through to just dive into this case. I was going to do an end-of-year review on the Innocence Project and kind of look at their annual report, but I saw this petition come across I get their mailing list, their text message mailing list. And I saw this come across, and not only is it urgent because he could be executed at any time, but I was like, wait a minute. I know that name. We've been here before. Because I remember this in 2017. I remember the clock was ticking, and then I heard at the last minute that he was saved from lethal injection, minutes, hours, whatever, before it looked like it was over. So instead of looking at the annual report, I was like, let me grab this together and let's talk about it, because it's crazy. And you've got the people with prosecutorial power saying there's absolutely zero chance, and I vehemently disagree. I strongly disagree that there's zero reason to doubt this conviction. And again, if you want to sign the petition to help stop the execution of Marcellus Williams or share it, the link is in the description below. I'm going to jump off and start editing this so I can publish it and talk to you guys, and by the time you hear this, you'll have been done watching it. So share your thoughts. You guys take care. I think a little bit of discussion like this can go a long way in raising awareness and helping advocate for the next innocent person that needs someone to advocate for them. Take care.